We are live on YouTube. Thank you. Phone number ending at 997. You have your hand raised.
Kelly, do you usually
Hello, this is Mary Ann Widener with the Clark County Assessor's Office. Can you hear me? I know you can hear me. I'm not sure if they can hear me.
Mary Ann,
Hello?
this is Commissioner Bursey. I can hear you.
Oh, okay, great. I just wanted to make it known that I am here for an item that's on the consent agenda. It's item, sorry, I got to pull it back up now again. It's item
You probably
B.
you probably need to tell Tina and not me.
Okay.
I'm
Well,
listening.
Hello, Tina. This is Mary Ann Widener with the Clark County Assessor's Office. I'm here for item 3. D, consideration or approval for the administrative law judge's recommended decision regarding the appeal of property tax abatement for the Howard Hughes Company, LLC. I know it's on the consent agenda. I just wanted you to know I was in attendance.
Thank you very much.
Thank you.
All right, there you go. You're good to go.
Yes, thank you.
Bye.
Bye-bye.
Hello, Miss Warren. This is Tina. You have your hand raised. Miss Warren, can you hear me?
Okay, it's 9 o'clock. I'll call the meeting to order. This is the Nevada Tax Commission meeting for August the 16th. Tina, would you please call roll of the commissioners, please?
Yes. Commissioner Wren? Commissioner Wren is present. Commissioner Brown?
Present.
So I don't need to talk.
Commissioner Witt?
Present.
That's why.
Commissioner Bursey?
I'm here in Utah.
Commissioner Littman?
Present.
Commissioner Johnson?
Present.
Commissioner Byram?
I'm present.
And Chairman DeVold.
Okay, I'm present as well. So I take it we've got Commissioner Wren and Commissioner Byram in person in your office. Is that correct? Okay, very good. Okay. This,
One moment, YouTube Live, we were just told is not working for some reason. Hold
Okay.
one moment.
thank you.
All right, thank you. It is working.
Okay, very good. I want to thank everyone for their patience as we continue on with remote and semi-remote meetings with masks on. I appreciate everyone's patience with this. I know it's not as easy as being in person, so thank you. At this point, we've got public comment. If you would, please use the raise your hand key at the very bottom of the screen. If you would like to provide public comment, or dial *9, and your public comment will be taken in turn through Ms. Padavano. Please remember that you have 3 minutes maximum for public comment. So Tina, with that, let's invite public comment.
We have Neil Jones providing public comment. One moment.
Thank you. My name is Neil Jones, and I ask that the statement be included in the minutes of this meeting. My public comment is a follow-up to my public comment at the June 25th, 2021 Tax Commission regarding the apparently deceptive financial practices of Nye County and the town of Belmont, which, with the full knowledge and backing of Nye County, defrauds the government and its citizens of tax revenues. The invented town of Belmont is not a legitimate governmental entity or local government. This commission is the head of the Department of Taxation and is designed to supervise the overall administration and operations of the Department of Taxation. This commission has the statutory authority to make decisions to ensure that the application of taxes is done consistently among taxpayers and among various taxes. In 1991, the legislature of Nevada enacted a Taxpayers' Bill of Rights, which laid out the rights and responsibilities of taxpayers. This statute mandated that the Department of Taxation adopt regulations to carry out the provisions of the statute. The statute established provisions for how and when the department shall respond to written requests from taxpayers. Nowhere in the statutes of this state are there provisions for imaginary entities to be landowners or considered to be tax exempt. But it appears that these fictitious entities have more rights in being protected and avoid paying taxes than the taxpayers of this state do in trying to get these phantom entities to abide by the established laws and have the persons associated with them held accountable and responsible for their actions. In the nearly 15 months since these issues were first brought to the attention of the Department of Taxation in an email to Mr. Jeffrey Mitchell on May 19, 2020, no responses to any written request have been forthcoming from the department. It's been over a year and a half since I sat before the Tax Commission at your January 27, 2020 meeting to publicly voice taxpayer concerns to the Commission regarding other questionable financial practices of Nye County. Again, nothing comes of these stated concerns to the department. I have submitted a petition for an advisory opinion to the department, which is attached to my previously submitted written public comments for this meeting. I look forward to the prompt written responses from the department, the Tax Commission, and the Committee on Local Government Finance to the submitted written requests and the courtesy, fairness, and common sense treatment of concerns of a taxpayer as are mandated by statute. Thank you.
Okay, thank you, sir. Just as kind of a follow-up, we have not been ignoring you. The Attorney General's office is working on a response for the Committee on Local Government, and they're working on an advisory opinion. Deputy Attorney General Peter Kagan has been assigned to this. We have 45 days to respond to the advisory committee, the advisory opinion, and respond to your request. We can also request a 15-day extension. It's inappropriate to send a 41-page public comment to the commissioners, and we are dealing with this, Mr. Jones, so thank you for your comments. Tina, the next comment.
If anybody has public comment, please dial *9 or raise your hand and you'll be put into the queue. I don't see any additional public comment. Thank you.
Okay.
Unless there's any in the room. Is there any public comment? No. No public comment.
Okay, very good. Let's see, in the absence of Director Young, our newly, about to be newly crowned Executive Director, Shelley Hughes, congratulations, by the way. We're all looking forward to working with you. Could you please administer the oath to all parties that plan to testify today, please?
Yes, and thank you very much. For those all present and on the Zoom call, by testifying today, you are swearing to tell the whole truth in the proceedings today. Thank you.
Okay, very good. Next item is the meeting minutes. Is there any additions, corrections to the June 25th Tax Commission meeting minutes? If not, is there a motion to approve those minutes?
Commissioner Brown makes a motion to approve.
Commissioner Witt, second.
Thank you very much. All those in favor, please signify by saying aye.
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 Aye. Aye.
Anyone opposed? Okay, very good. Thank you, commissioners, for identifying yourself for the court reporter as well. That's very helpful. Okay, now we've got the consent calendar. I know Commissioner Brown has a disclosure to make, and I'll allow him to do that before we consider the consent calendar.
Mr. Chairman, I'm happy to make the disclosure now, but I thought that we were going to remove item 3G from the consent agenda before that. How would you like to proceed?
Your choice. I'm happy to do it at that time. We'll remove item 3G. I believe Commissioner Wren was planning to do that. I'm not privy to that, but let's go ahead and pull items from the consent calendar. Is there anything that anyone would like to pull?
This is Commissioner Wren. I have two items I'd like to pull from the consent agenda. Item 3, number 3, item D, consideration of approval of the administrative law judge recommendation, the Howard Hughes Company, and also number 3G, approval of refunds in accordance with the decision of the Nevada Supreme Court dated May 13th, 2021.
Thank you, Commissioner Wren. Is there any other items any of the commissioners would like to pull? Okay, could I get a motion to approve the consent agenda, which includes bonds administratively waived, waiver of penalty interest pursuant to a request for voluntary disclosure, waiver of penalty and interest pursuant to NRS 360.419 that exceeds 100,000, consideration for approval of administrative law judge's decision on the appeal and denial of waiver of penalty and interest, and department's recommendation for commission approval for offers in compromise. So items 3B, C, D, oops, I apologize, exclude D, E, F. Could I get a motion to approve the consent calendar?
Commissioner
So
Witt, move to approve.
Commissioner Byram, second.
I've got a motion and second. Any other discussion? All those in favor, please signify by saying aye.
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 Anyone opposed? Okay, very good. Commissioner Wren, item 3. So if you're on the phone and your item was on the consent calendar, you're free to leave now. Your item has been approved. If you would like to listen to the remainder of the tax commission meeting, you're more than welcome to do so. Okay, Commissioner Wren, item 3D. Commissioner Wren, it looks like the conference room is on mute. We can't hear you.
Sorry, is that better? Is that better?
Yes, it
Okay.
is. Thank you.
All right, thank you very much. This is this deals with Howard Hughes. This is a pretty large case. It's 400 and some pages. I would have preferred seeing it as being heard instead of on the consent agenda as large as it is, because I'm not sure my questions can be answered today, but I'm going to give it a shot. This whole case boils down to whether or not two parcels were either remainder parcels or new parcels. Going through the case, it appears to me that according to a February 2018 map, the parcels in question had already been designated as an employment center. The large lot final map was approved apparently in March of 2018. Those were deemed to be employment centers again and made new parcels instead of remainder parcels. So my question is why? It appears to me they should have remained as, excuse me, appears they should have remained as remainder parcels. So Jeff, you want to take a crack at it, or Mary Ann?
Thank you, Jeff Mitchell, for the record, Deputy Director of Local Government Services. As mentioned, and maybe I'll just give a brief overview of the case. This case was an appeal of the proper application of the property tax abatement. In general, we forward those cases onto the administrative law judge because they can conduct a hearing in such a manner that you're requesting and receive testimony from all the different parties. And they therefore make a recommendation to the tax commission on that case. As to the specifics of the case and the application of the new parcel, that probably is a better question for Mary Ann to, as I don't want to speak for them.
Okay. Wilder?
Hello, this is Mary Ann Widener with the Clark County Assessor's Office. Commissioner, would you like me to respond?
Yes, please.
Chairman, this case was heard by the administrative law judge, and all parties were enabled to present their materials to the administrative law judge. The conclusion of the assessor's office, I'm just going to talk about it in broad terms, was that this was not a remainder parcel. We had put forth regulations back several years ago, and actually the Nevada Tax Commission, U.S. Commission, approved for us to reopen those regulations, and we went through many workshops to try to resolve an issue, and Howard Hughes was probably one of the largest stakeholders that was in this, because it was a lot of parcel cuts that came through their developments as they sell off parcels and they start developing. Because we were having some problems determining what a final cut was on a parcel, and the previous regulations permitted, it didn't really follow what the statute said. And then we had a Supreme Court decision, which the administrative law judge references and is in the materials, as you mentioned, many pages of materials, that determined, for there to be a remainder parcels, there had to be new parcels for development. And in this case, there were two, and both of them. And so one of the distinctions in the regulation was to say, if they filed a subdivision map, well, in the regulation, it said commercial or industrial subdivision map for commercial or industrial use. And there was a confusion with this particular map because it was a mixed use map, which included both residential and commercial uses. So it wasn't filed in the same way that some of the others have been filed. But the intent of the law was still there. And I think the administrative law judge made a good conclusion where she determined that the assessor's office actually had applied the regulation appropriately and not given this parcel and another parcel very similar to it, which was not a part of this appeal, a remainder. In fact, the parcel itself had a building. Permits had been pulled to actually begin to build the building that was going to be placed on it. And the petitioner had the opportunity to file to the Nevada Tax Commission in opposition to this, where we would have actually heard that case today. They did not do so. And so that's why it went on your consent agenda, because there was no opposing parties to the conclusions of the administrative law judge. So I'm trying to speak in very broad terms, but if you have any more specific questions, I'd be happy to answer them.
Well, and as you can imagine, that's somewhat my concern, since the other side isn't here also. And of course, I've been very involved with this over the years, so I understand the confusion and what's attempting to be done. But this just appears to me to be one of those cases where, in fact, these parcels were already deemed employment centers before the large lot final map was done, which is, I think, kind of a funny thing to name it, because that's not a commercial map or a industrial map. So my concern, or my opinion anyway, because of the dates that I have, it appears that these should have remained as remainders and not new parcels.
So I'm going to respond via the chairman, if I may.
Yes, please. Yes, please.
Okay. I don't believe that, and I'm not trying to tell the commission what to do, but it hasn't been agendized for us to actually debate the conclusion. So if the tax commission is rejecting the administrative law judge's conclusions of law, then I suppose it would be at your discretion to reopen the case and have it heard. But again, there's some legal parts of that I don't know why it could be reopened at this point, because there's no opposition to the administrative law judge's decision. And so, it's up to the commission whether they want to hear all the facts of the case or whether they want to, accept the administrative law judge's decision. But if you would like us to present the facts of the case, then we're not prepared to do that today, and obviously the other party's not here either.
And Mr. Chairman, that was my concern when I pulled this. I knew that that's where we would get, because of the amount of parcels that we have in the state of Nevada in the 17 counties, and this relatively large change in what becomes a remainder and what becomes a new parcel. I hate setting a precedent just by having on the consent agenda. I would appreciate if we could pull it and agendize it at a future date so we can hear both sides.
Commissioner Wren, I think this has been ongoing for several years. I mean, for almost as long as I've been on the tax commission. For us to retry a case that's already been presented in front of an administrative law judge, that's really what the administrative law judge process is for, so that we're not going through this ourselves. So I would not support pulling this agenda item. We've come to a conclusion that all parties are in agreement with, and I would not be supportive of that. But let me welcome comments from the other commissioners. I'll call them one by one. Commissioner Brown, your thoughts?
To be honest with you, I don't feel the need to pull it as well, but I did reach the same conclusion that Commissioner Wren reached regarding the remainder parcel. So that would be my comment.
Thank you. Commissioner Littman?
I agree with you, Chairman DeVold. I think this has been litigated before an administrative law judge. My understanding is that the taxpayer actually is on the line, or a representative for the taxpayer. I thought I heard someone notify Tina that they were on the line, so perhaps hear their comment. But the taxpayer had the opportunity to contest this decision, and they have not. So I think due to economies and efficiencies, I would not pull the matter, and I would approve the administrative law judge's decision. And I'm happy to make a motion to that effect.
Okay. Commissioner Bursey?
I'm ready to go forward and vote on Commissioner Littman's proposed motion. This matter has been thoroughly vetted, thoroughly argued, and I think also on the basis of time and experience that we should just go forward with it.
Okay, thank you. Commissioner Witt?
I would agree that we are ready to vote on this. As I digested the 400 plus pages, it brought back the memories of going through it previously. We have just from being here for a while, and it was one of the more interesting cases that we dealt with, and I think we've thoroughly dealt with it.
Okay, thank you. Commissioner Johnson?
Yes, I would agree with the chairman that I think it's ready to be voted on without, it doesn't seem there's a proper appeal before the commission. So I don't think that we can actually rehear the whole matter. So I think we should vote on it.
Thank you. Commissioner Byram?
Mr. Chairman, I had also marked that to be pulled because I wanted to hear the arguments, because I think I see that there's been a history that predates my time on the commission. However, it went to regulatory workshops, and here we are again without a bright line test, with a little uncertainty. I mean, both arguments are I can understand both sides of the argument. It seems that if the use hadn't changed, and it should be a remainder parcel, and they'll pick that up when it does change and when it is the development does begin. So Commissioner Wren knows a lot more about property than I do, but it just seems like it's a shame that we went through a regulatory process and we still have questions about how something's defined. And it seems to me that if we're not going to open this and hear it, it's going to keep cropping up over and over until there's more clarity in the regulations. And so if we aren't able to hear this again, we should at least get those really smart people that already went through this and wrote the regulations, who are still arguing it, Clark County and Mr. Bancroft and Howard Hughes Corporation, and get the folks together and say, here's what it would take to make this more clear, so that we don't end up arguing this, spending our resources, and end up in front of the commission again. That's my thought.
Thank you, Commissioner Byram. I believe Commissioner Littman had a motion. I'll hear that now.
Okay, I would move to approve the administrative law judge's recommendation decision regarding an appeal of a property tax abatement pursuant to NRS 361.4734, consent agenda item D1.
Commissioner Bursey seconds.
Okay, I've got a motion and second to uphold the administrative law judge's opinion. Is there any other discussion? Okay, I'll take a roll call vote. Commissioner Brown,
No.
Commissioner Littman,
Aye.
Commissioner Bursey,
Aye.
Commissioner Johnson.
Aye.
I apologize. One more time.
Aye.
Commissioner Witt,
Aye.
Commissioner Wren,
Nay.
Commissioner Byram.
Nay.
Chair votes aye. Motion passes 5-3. Next item on the agenda, Commissioner Wren.
Item D, and
Mr. Chairman, I apologize for interrupting, but may I make a disclosure before we hear this item?
Yes, please.
Thank you, Mr. Chairman. I'm going to be recusing myself from this item and not participating in the discussion for two reasons. I am a member of the board of directors of one of the plaintiff organizations in this matter, and I'm also related to the CEO of another member organization who is a plaintiff in this case. So I will be withdrawing from participation.
Okay. Thank you, Commissioner Brown. Okay. Commissioner Wren, questions, please.
okay, I don't have any further questions on this one. I'm prepared to make a motion unless there's other questions before a motion needs to be made.
Are there any other questions on this topic? Okay, very good. Go ahead, Commissioner Wren, please.
Okay, thank you. I would move to approve the refunds in accordance with the decision of the Nevada Supreme Court dated May 13th, 2021. In the case of the legislature of the state of Nevada, the Honorable James A. Settlemeyer, case number 81924.
Commissioner Littman seconds the motion.
Okay, thank you. I've got a motion and second. All those in favor, please signify by saying aye.
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 Anyone opposed? And please let the record note that Commissioner Brown has abstained from voting and the conversation on this topic. Okay, thank you. Next item on the agenda is Division of Local Government Services, item number 4A. Director Hughes, go ahead and announce that topic, please.
Sure. Number 4A, Department's recommendation to not accept jurisdiction of appeal filed according to NRS 361-4734. The first item on the agenda is Kimberly A. Levine, and we have Jeff Mitchell representing the department.
Good morning, Mr. Chairman and members of the commission. Jeff Mitchell for the record, Deputy Director over Local Government Services. For you today is a recommendation to not accept jurisdiction to hear this appeal. This appeal was filed on our property tax appeal form that can come before the Tax Commission. The areas that can come before the Tax Commission are appeals according to NRS 361.4734, which is an appeal of a decision rendered by a county assessor or Department of Taxation regarding the applicability of the partial abatement, or NRS 361.4835. The taxpayer or the petitioner marked that this was a petition regarding the abatement, and then in the packet provided information that it might be a penalty and interest. Upon conversations with the petitioner and upon reading the further documentation provided, she is appealing the special improvement assessment, which is under NRS Chapter 271. And NRS Chapter 271 does not fall under the jurisdiction of the Tax Commission. And although I have sympathy and empathy for the documentation provided, this is not something that the Tax Commission in my opinion, has the authority to hear an appeal on. And so the recommendation is to not accept jurisdiction. I believe the petitioner was planning on being available by phone.
Miss Levine, if you are on the telephone, please dial *9 or raise your hand.
And with that, I am available to answer any questions that I can.
Kimberly Levine is on the telephone.
Good morning.
Ms. Levine, go ahead.
Yes, it was not, I'm sorry, I'm down ill with the flu, and I did contact an attorney, Lawrence J. Semenza, who has not yet decided whether to take the case or not take the case, so I'm asking for an extension. It's not that I'm looking for the appeal as much as the audit. So I understand your position on the appeal. I do need the payment history audited, in which the city is unwilling to do so. And so I believe it is the state's jurisdiction to oversee that these payments are audited. As you can see on 8/27/09, which is 1 month after I purchased the property, it looks as if the assessment, which is a special tax, was paid in full. So I'm not looking for any fault on the behalf of the taxation department. It's just my belief that it is up to the state to audit the payments. And again, so I'm looking for an extension on this to see if the attorney is willing to help me to decipher what the law and whose obligation. And I do apologize. I am down with the flu this morning and a little bit, not all, quite all there. So if that's possible, if we could look at an extension of to the next hearing date.
Okay. Thank you, Ms. Levine.
Yes.
Mr. Mitchell, do you have a response, or is there a way that we can get her to the correct jurisdiction and help the taxpayer? I think that's what I would really like to see. If we don't have jurisdiction, could we help her get to the correct place to hear her appeal?
Mr.
Or
Chairman,
audit?
Mr. Chairman, Jeff Mitchell for the record. I will do my best to do research on the proper board and authority to hear the appeal. I believe that it is the city of Las Vegas with whom the special improvement district is created under. That would be the appropriate authority and route to challenge and to audit, as Ms. Levine has said.
That would be great. To challenge an audit would be my hope.
Mr. Mitchell, it does sound like her choice to secure legal counsel and go forward with the city of Las Vegas would be the appropriate approach at this point. Would you agree?
I would agree.
Okay, very good. Okay, this is an agendized item for vote. It's recommending not to accept jurisdiction. Is there any other discussion, or is there a motion?
Commissioner Brown,
I'd move to approve.
Commissioner Littman seconds the motion to approve the department's recommendation.
Okay, I've got a motion by Commissioner Brown, seconded by Commissioner Littman, not to accept jurisdiction on the appeal filed according to NRS 61.4734.
Okay, but I understand the appeal. We're talking about the audit, not the appeal.
All those in favor, please signify by saying aye.
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 Anyone opposed? Ms. Levine, this is jurisdiction regarding an appeal that's on our agenda. We can't change what's on the agenda.
Okay, I understand that. So I still do have the position to have asked for an audit. Is that correct? as I have requested counsel who has not yet chosen to represent or not represent me.
Yeah, let me help. I think you need to grab legal counsel and go through the correct jurisdiction. The Department of Taxation does not have jurisdiction under this to
Okay, I'm not, but
excuse me.
But we have a difference of how this was. It says audit and or appeal. I'm not looking for the appeal. I'm looking for the audit. That's where I think the confusion is.
So what's on our agenda is an appeal, and it's been declined. You've lost your jurisdiction appeal, and your audit needs to go through an attorney. Could you let me finish, please?
Yes, certainly.
Please.
Certainly.
Could you please let me finish?
Yes.
Go get an attorney and go through the correct procedure. Next matter.
Which is
next
what?
Matter. Ms. Hughes, could you go ahead with the next agenda item? Thank you.
Yes, thank you. Thank you, Chairman. Next item is 4B, consideration for approval of a reappointment to the Appraiser Certification Board. Item number 1 is Soren Popo and Jeffrey Mitchell will be presenting for the department.
Good morning, Mr. Chairman and members of the Commission. Jeff Mitchell, Deputy Director of Local Government Services for the record. Under NRS 361.221 sub 2, the Appraiser Certification Board consists of 6 members, 3 of whom are chosen by the Assessors Association and 3 of whom are appointed by the Nevada Tax Commission. Soren Popa has served on the Appraiser Certification Board for, I believe, 4 years now. And his term came up in June, and we are seeking reappointment for another 2-year term for Mr. Soren Popa. He is currently supervisor of the centrally assessed property section within local government services. He joined the department in 2015. He is currently certified as an appraiser. He holds a PhD and a master's in finance and is also a certified public manager. And we would seek for Mr. Popa to be reapproved.
Is there any questions of any of the commissioners of Mr. Mitchell?
This is Commissioner Wren. I would move to approve the appointment.
Commissioner Byram, I deal with Mr. Popa all the time, and he's been great to work with. He's very good at what he does, and I would second the motion to approve him.
Okay, very good. We've got a motion and second. Any other discussion?
Thank you for your service, Mr. Popa.
Okay, got a motion and second. All those in favor, please signify by saying aye.
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 Anyone opposed? Very good. Thank you, Mr. Popa.
Thank you.
Director Hughes, next item.
Next item is under the Compliance Division, 5A, Department's recommendation to the Commission for denial of an offer in compromise pursuant to NRS 360-263. The first item is Jose Iglesias, and we have Adrian Roberts Larson presenting for the department.
Good morning, Mr. Chairman and members of the Commission. Adrian Roberts Larson for the record. Jose Iglesias has submitted an offer in compromise to settle debt on 2 accounts, CC Pizza number 2 LLC and CC Pizza number 3 LLC. The business is operated as a CC's Pizza and both locations are closed. The offer is to pay a total of $50,000 in monthly payments of $400 and is based on the reason of doubt as to collectability. The combined outstanding debt totals $245,047.15, comprised of tax only in the amount of $164,597.44. A review of his personal financial statements shows that his expenses are above the national standards. He is behind on his mortgage statements. Credit card statements are extended. And normally when the department would look at the financial position that was presented by him, we would recommend approval due to his age and financial situation. However, when we researched the information further, we found that at the time that the offer was submitted, he had a third business that was open and operating.
I asked him.
He also is on reserve standby for a law office that he has worked for the past 21 years. So he still has earning potential. On that particular law office page, on the contact page, it lists him as the paralegal and investigator and has a contact link to him directly. Through research and review of the documentation, the department also looked at potential other responsible persons that we could pursue for the debt and found that it is out of statute. Mr. Iglesias is liened for the majority of the debt as well. So we are recommending that the tax commission deny the offer based on the reason of doubt as to collectability. And I'm happy to answer any questions for the commission.
Thank you, Ms. Roberts-Larson. Is Mr. Iglesias on the phone or online?
I'm online.
Could you go ahead and make your case for us, please?
Yes, sir. The reason I was asking for this payment is, yes, I do had a business open, which I closed it down because of there was no more money to pay my employees and rent and everything. With Mr. With the law firm working, I'm on standby, but we haven't worked for almost more than a year. And there haven't been any cases down. And right now I'm suffering a lot on money-wise. Right now I'm going to start working with a company, which I put an application for on track to deliver package and everything. I know company owes you all this money, and I owe you this money. I'm the person who was responsible because the owner was Michael A. Paul for TC's, and I was the manager, and I'm responsible because I told him I was going to take care of it. There was another person involved in there. There was Terrence Wright and Kim Wright, which were my partners in that time. And I did send them the money to pay and everything, but they were not paying nothing, sir. And by the time I knew that, it was too late. But I'm willing to pay whatever you want me to pay, but just give me some small payments so I can not be, out of the budget. I feel responsible for all this, and I'm so sorry this came all this way.
Ms. Roberts-Larson, do you have any other comments to add?
Yes, sir. Mr. Iglesias did make us aware just about a week or so ago that he did close the third business. And that was one of the major conversation points between the department and Mr. Iglesias at the time he submitted this offer, was the fact that he did have an open and operating business that we were just simply unable to see how he was funding it. And at that time, he refused to close it. I did anticipate that once he told us that the business was closed, that this might be remanded back for further discussion. But that was a new development, again, after all the materials and the recommendation had been submitted to the commission.
Okay. It sounds like to me that we should remand it back to you and let both parties try and come up with something that is reasonable. If Mr. Iglesias, if you could be as cooperative as possible with financial information, and that would speed the process, and then we'll reconsider, is kind of my thoughts. Is there any other discussion or comments on this topic?
No, sir.
Thank you, Mr. Iglesias. I'll bring it back to the commission now. Is there any questions of the taxpayer or the department? Is there a motion to approve the denial and remand back to the department?
Commissioner Littman moves to approve the denial of the offer and compromise of Mr. Jose Iglesias. And we hope the taxpayer and the department can work out a subsequent offer and compromise.
Commissioner Bursey seconds.
Okay, thank you. All those in favor, please signify by saying aye.
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 Anyone opposed? Okay, very good. Offer and compromise has been denied. Mr. Iglesias, please work with Ms. Roberts Larson to provide an amended offer and compromise. Director Hughes.
The next item on the agenda is 5A2, Alan Silberstein, and we have Adrian Roberts Larson representing the department.
Thank you. Again, Adrian Roberts Larson for the record. Alan Silberstein has submitted a request for offer and compromise on Gamblers Trading Company. The business operated under the DBA names of Gamblers Book Club, Gamblers General Store, and GBC, collectively from March 2010 through January 2018. The outstanding debt totals $121,181.75, comprised of $87,670.37 in tax. The reason for the request is based on doubt as to collectability. Mr. Silverstein states that the business is closed and that taxpayer has no assets or income from which the department could collect. The offer is to pay $2,375 in monthly payments of $475, and to date, no payments have been received. The business was audited in March 2017. The taxpayer timely petitioned and a redetermination was made. In response to the redetermination, the taxpayer requested a hearing. The administrative law judge upheld the redetermination and the taxpayer petitioned that decision. The matter was heard by the Nevada Tax Commission on January 27, 2020, and remanded back to the ALJ. Additional information was provided by the taxpayer and the assessment was revised. As final resolution, the taxpayer and the department entered into a settlement agreement on October 5th of 2020. On October 23rd of 2020, Mr. Silverstein's offer and compromise request was dated. He is the sole officer of at least two other businesses that are currently operating, Cardoza Publishing and Nevada Gaming Chip. On his financials, he lists distributions from other businesses as well. Through his counsel, he has stated that his involvement in the other businesses is from quite some time ago. However, a fifth entity was not disclosed to the department, nor is it listed on his IRS tax returns. No income has been disclosed for that particular business. There's 2 points at hand here. One is the default of the settlement agreement. In the settlement agreement, it states that he can enter into a payment agreement to pay that debt, as opposed to paying it in one lump sum. And there's the issue of doubt as to collectability, that through the financials that were provided by Mr. Silverstein and his counsel, the department feels he has future earning potential and that the offer amount is unreasonable. So the department would ask that the commission decline the offer and compromise, and we recommend that Mr. Silverstein adhere to the settlement agreement that was agreed upon last October. Thank you.
Thank you. Is the taxpayer, Mr. Silverstein, on the phone or online?
Suzanne Warren is on the telephone as a representative.
Good morning. Could you state your name and spell it for the record, please?
Oh, this is Alan Silverstein. I don't know if you hear me.
Yes.
Oh, okay. Sorry. Hello, everybody. Yes, Suzanne is representing me. I don't know if she's able to talk, but she's on the phone. I don't know if she can.
Good morning. Good morning, Chairman and Commissioners. I'm sorry for the technical difficulties. This is Suzanne Warren on behalf of Gamblers Trading Company. Can you all hear me?
Yes, we can.
Great, thank you. Good morning, and thank you for having us here today. We are asking for the Commission to approve the taxpayer's offer and compromise. Let me be clear that this is the debt from Gamblers Trading Company, not Alan Silverstein. The department has not made a responsible person determination as of yet. Unfortunately, I did send a pre-hearing statement approximately 2 weeks ago to give you our context on the history of this case. The department has not provided that to you. So I'm asking for a little bit more time to give you the history. I think Ms. Adrienne Roberts-Larson has preliminarily given you a good history. This business has been closed since approximately May 2017. The department did audit the business starting in early 2017, and the business has been closed again since May 2017. The audit was originally for approximately $140,000. We did reach a settlement agreement. Settlement agreement currently stands at approximately $85,000, including penalties and interest. And the commission approved that in October 2020. We did submit an offer in compromise. We amended that up to a figure of $10,000. The offer was submitted as to doubt as to collectability. The business is, again, out of business. There are no assets and there is no income being generated from the business. The department requested personal records as to Mr. Silverstang, and those were provided. Unfortunately, the department denied and stated that the taxpayer was intending to evade or prolong collections and has threatened to default the prior settlement agreement, indicating that they're unwilling
reporter,
to
everything's
cooperate.
frozen. I don't know if it's frozen for everyone else. I'm going to log out and come back in.
Okay, can you still hear me?
Now I can. Now I can.
Yes. Ms. Warren, could you hold on for just a moment, please?
Sure.
Our court reporter is having some difficulty, and maybe if you don't mind slowing down just a hair.
Oh, it just froze, and so I ended at, unfortunately, the department denied and stated that the tax.
I'm sorry. Could the court reporter tell me the last sentence that you heard? And then Ms. Warren, if you don't mind, could you maybe rehash those comments afterwards, please?
Sure.
Yes, sir.
It just froze up and ended at, unfortunately, the department denied and stated that the tax.
Okay, are you ready?
Yes.
I can slow down. I'm sorry.
Thank you.
Yes, unfortunately, the department denied the offer and indicated that it was not willing to accept any resolution for this case besides full payment of the agreed upon amount. Otherwise, the warning was that the department would default the prior settlement. Mr. Silverstang's current financial status is this. Again, assuming that this is personal liability, which the department has not found a responsible person determination as to Mr. Silverstang. Mr. Silverstang does not have any assets besides his personal furnishing. He does not own a home. He rents. He has treasury debt owed in the amount of approximately $65,000. He has no equity in his car. He has cash on hand of less than $5,000, and he has sole custody of 2 minor children and has no support for those children besides himself. He does not earn any W-2 wages. His flow-through income from his partnerships was disclosed to the department. That flow-through income is approximately $6,800 a month. He has no health insurance because it's too expensive. His living expenses are less than the IRS national standards. Combined with his housing expenses, those are within approximately $500 of the IRS standard. His transportation costs are within $100 of the IRS standards, and his expenses don't account for what the IRS would allow for either health insurance or current tax obligations. So today we are asking for the commission to either approve the originally submitted offer of approximately $2,500 or upwards to $10,000. And we are asking for the commission's help because the department has indicated that it will default the prior settlement and will not accept anything less than a full payment. And that is simply not possible. There are no assets and there is insufficient income to pay this debt. We have cooperated. We have disclosed all of Mr. Silverstein's personal finances, and we are literally here asking for the Commission's assistance in how to resolve this matter. Any enforced collections by the department, it is our belief, would be fruitless. There are no assets that the department can protect with a lien. There are no wages to garnish. There are no accounts receivable to levy. And so with that said, our offer is reasonable. The department can collect something just as any creditor would when compromising a debt. And the department can have freed up resources to collect from other viable sources. I hate to say that the department has indicated that there's bad faith on this, but again, they will not provide any alternative. They have indicated that their intent is to fall back on the settlement agreement. And so we are asking for the Commission to consider the offer in compromise. In the alternative, remand for consideration of an offer in compromise with full cooperation from the department. And above all, we are asking for a finding and order from the Commission that the department is prevented from defaulting the previously agreed to audit settlement. Thank you for hearing us on this matter. And of course, we are here and we are willing to accept or answer any questions from you. Thank you.
Thank you, Ms. Warren. Ms. Roberts-Larson, do you have any comments before I bring it back to the Commission?
Yes, I do. Thank you, Mr. Chairman. Again, Adrienne Roberts-Larson for the record. Yes, the department, in fact, in the memo to the Commission has stated that we feel that the settlement agreement was entered into with the already intent of violating what we would call a covenant of good faith and fair dealing, which is Mr. Silverstein, being president and owner of Gamblers Trading, signed on behalf of the settlement agreement as full and final resolution of the audit debt to pay that amount agreed upon. And then within a matter of days, turned around and submitted an offer in compromise to the department, to which no amount, whether it be the $23.75 or the mentioned $10,000, has been paid to the department. The department is prepared to pursue Mr. Silverstein as a responsible person. He was the sole officer of Gamblers Trading. We do still maintain and feel that given the financials provided, he does have the ability or may have the ability in the future to pay through an increased offer. And we are holding to the amount that was agreed upon in the settlement agreement. Thank you, sir.
Okay, thank you. Are there any questions from any of the commissioners of the taxpayer or the department?
Mr. Chairman, Commissioner Byram, I have a question for Adrienne. What would it take to get the responsible party designation, or how quickly can that be done? And also, second, is there a time certain that the negotiated amount needs to be paid before it defaults to the full amount?
Thank you for your question, Adrienne Roberts-Larson for the record. So to answer the first part of that, the department and my staff, we already have a responsible person determination prepared. We're just finalizing it. I was waiting on the outcome of this particular tax commission before I moved forward with submitting that. However, I can have that noticed in a matter of days, and I'm not sure where we are at on hearing dates, but I do know that we have upcoming dates for, I believe the next that could be noticed for would be like October. I think we've missed September. With regard to the second part of your question, are you talking about default on a settlement agreement? Like if there's a time frame on that, am I correct?
Yes, that's what I meant.
Okay, so generally what happens with the settlement agreements is once they've been approved by the commission, they will actually come to usually to me and my team. We will then reach out to either counsel or the taxpayer, work with them to either arrange payment in full or payment agreement terms. Because so much work goes into settlement agreements, we don't take any type of collection action or say a default lightly. In fact, we send a notice to cure. Often in the settlement agreements, there will be a provision for a particular time frame, such as 10 days, 30 days, 60 days, whatever may be agreed upon. If it's not specifically stated in the settlement agreement, as I do not believe it is in this one for Mr. Silverstein or for Gamblers Trading, we give an automatic 30 days to be fair to the taxpayer. Unfortunately, in this case, we did not have the opportunity to do that because, as I stated, the settlement agreement was agreed on whereas approved October 5th, and on October 23rd, we received an offer and compromise request. So again, pending the outcome of today's tax commission meeting, then we will proceed accordingly.
Thank you.
Thank you.
Commissioners, this is Suzanne Warren for the record, please.
Go ahead, please.
Just want to make quick note of the responsible person determination. We have not received notice of a hearing on this particular finding. I will note that a responsible person determination finding must be willfulness on the part of the taxpayer. So it is not simply that the taxpayer was or that the individual was the sole owner or president or CEO. It does require an extra factual finding of willfulness.
Thank you.
And Mr. Chairman, if I may just add a comment to that. Yes, we acknowledge we have not noticed Mr. Silverstein as a responsible person in this matter. However, we are prepared to do so. And the department feels and is quite confident, I'm quite confident that he'll be found responsible for the debts of Gamblers Trading. Thank you.
Thank you. I'm going to go back to the commissioners. Are there any other questions from the commissioners or from the commissioners to the taxpayer or the department at this point? Is there any other discussion? I'll entertain a motion.
Mr. Chair, this is Commissioner Byram. I'm sorry.
Yes, please.
I would like to move that we uphold the denial of the offer and compromise for Alan Silverstein. And
Commissioner Brown, second.
Okay. I've got a motion and second to deny the offer and compromise. Is there any other discussion from the commission? Okay. All those in favor, please signify by saying aye.
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 Is anyone opposed? Okay, thank you for your time, Mr. Silverstein and Ms. Warren. The offer and compromise has been denied. Director Hughes, next item.
Thank you. The next item is 5A3, Juan Orozco Gutierrez. Adrian Roberts Larson is representing the department.
Hello again, Adrian Roberts Larson for the record. Juan Orozco Gutierrez submitted an offer and compromise to settle debt on Universal Metal Works. The business operated as a manufacturer of fabricated metal and repair. The offer is to pay $20,000 in monthly payments of $150, and the reason for his request is based on doubt as to collectability. To date, no payments have been made. The outstanding debt totals $108,401.45, with tax only of $66,479.02. The debt is the result of a sales and use tax audit deficiency and finalized sales and use tax deficiency determinations. The taxpayer late filed both for the audit and deficiency determination, and the department declined to accept the petitions. The appeals were heard before the Nevada Tax Commission, and the matter was heard on December 7th, 2020. The NTC voted to deny the taxpayer's appeal, and the offer and compromise was received January 21st, 2021. A review of the account and documentation submitted shows that Mr. Orozco is 36 years old and employed. He has current and future earning potential with which to pay the department owing, and the department has fully secured all of the debt owing by filing liens against him. The department did mail a denial letter to him. His wife, authorized to speak on his behalf, I've had discussions with her regarding this, explained that the debt is final. There was a little bit of confusion as to whether it was or not and if it was still negotiable. And I explained the department's position. Ms. Gutierrez stated that she did not want to withdraw the offer. She wanted to go ahead and have it presented to the department. And since then, she has had several more conversations with the department to which her and her husband want to look at possibly selling a property and making a large lump sum payment towards this. So with that said, I would recommend that the Nevada Tax Commission deny the current offer that is before you due to the reason of doubt as to collectability. Thank you.
Thank you. Is the taxpayer online or on the telephone?
I'm on the telephone.
Could you state your name and spell it for the record, please?
Yes, my name is Juan Orozco Gutierrez. It's Juan Orozzo Gutierrez, Gutierrez.
Thank you. Could you go ahead and make your comments, please?
Yes. I don't have the money to pay. I'm sorry, but I do have a house I could my house that I could refinance maybe. But I got charged taxes on it because my invoices weren't worded properly. I installed most of what I did. That was my mistake. I didn't have help in the office. It was just me, the one man deal. But that's yeah.
So Mr. Gutierrez, would you be willing to submit a reasonable offer and compromise if we remand this back to the department and work with the department and provide full financial disclosures?
I would like to do that if that's possible. Yeah.
Well, I think that's my recommendation. It sounds like there's some options versus the $150 a month payments, which is probably not going to work for us. So is there any questions from the tax commission to the taxpayer, Mr. Gutierrez, or the department?
Commissioner Littman has a motion.
Okay.
Thank you. To approve the department's denial of the taxpayer's offer and compromise. And Mr. Orozco Gutierrez, we appreciate you working with the department to come up with another offer that works for the Department of Taxation. And thank you for attending today.
Commissioner Witt, second.
Okay, I've got a motion and second. Any other discussion? All those in favor, please signify by saying aye.
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 Anyone opposed? Okay, Mr. Gutierrez, the offer and compromise has been denied. Please contact Ms. Roberts-Larson to amend your offer and compromise. Okay.
Thank you.
Thank you.
Thank you.
Director Hughes, next item.
Thank you. The next item is item 5B, approval of refund credit requests in excess of $250,000. The first item on that agenda is Adidas American Inc. And we have Jennifer Roebuck representing the department.
Good morning, Mr. Chairman and Commissioner.
Good morning.
Jennifer Rook, Tax Manager for the Department. America. I'm sorry? Oh, no. Can you hear me okay?
It's a little choppy, but go ahead.
Fantastic. All right, I'll start from Adidas America Inc. Filed a timely request for a refund of sales tax in the amount of $582,906.32 by amending returns for the months of August 2017 through September 2019. Adidas America overreported taxable sales for two reasons. First, Adidas implemented new software, which was in effect a registration to potentially make purchases. The registrations were erroneously included as taxable sales in reporting. The second issue was that the ship from store sales recorded sales tax twice in the reporting system. In both cases, the overpaid sales tax was not collected from customers. The department reviewed the amended returns, explanation, and support, and agreed that the sales tax was overpaid and recommends approval for refund. I am available for questions, and the taxpayer's presence has been requested.
Okay, I don't know that we need the taxpayer. Is there any questions of the department?
This is Commissioner Wren. I move to approve.
Commissioner Byram, second.
A motion and second. All those in favor, please signify by saying aye.
Aye.
Anyone opposed? Okay, very good. Director Hughes.
The next item is 5B2, Desert Research Institute, and Jennifer Roebuck is representing the department.
Thank you. Again, my name is Jennifer Roebuck, tax manager for the department. Desert Research Institute filed a timely request for a refund of live entertainment tax in the amount of $924,998.98 by amending returns for the months of May 2019 through June of 2020. Desert Research Institute collected and remitted live entertainment tax to the department for 4 events: Supercross, Monster Jam, World Cup, and NFR, which were canceled due to the COVID-19 pandemic. The revenues collected were remitted back to the customers, including the tax. The department reviewed the amended returns, explanation, and support, and agreed that the live entertainment tax was overpaid and recommends approval for refund. Again, I'm available for questions, and the taxpayer's presence has been requested.
Thank you, Ms. Roebuck. Is there any questions?
Mr. Chairman, this is Commissioner Brown. I do have a question.
Yes.
Thank you. I'm familiar with the Desert Research Institute, and I'm also familiar with some of these events, the NFR and Supercross. Maybe someone could explain to me. I don't understand how DRI is involved in producing, the National Finals Rodeo, and I'm just curious.
Commissioner, this is Jennifer Roebuck for the record. According to their account, there are 3 locations under Desert Research Institute. They are UNLV Thomas and Mack Center. I'm sorry, there's only 2. UNLV Thomas and Mack Center and Sam Boyd Stadium. I hope that answers your question.
So, Ms. Roebuck, I think where Commissioner Brown was going is DRI the conduit for those events? Do people, when they pay for those events, they pay the Desert Research Institute?
Thank you. There are actually different locations that are on the account. So we have, for example, location 5, and I apologize, I don't have the account up in front of me right now, but I do have the returns. Location 5 is the UNLV Thomas and Mack Center, and that is one. And then the other one is location 4 for the Sam Boyd Stadium. So I don't have the information on how they were registered. I do know that that's how the account is set up at this time. I don't know if there's a taxpayer representative on the line who can also speak to that a little bit more completely.
Is there someone from the Desert Research Institute on the telephone?
If anybody from Desert Research Institute is on the telephone, please dial *9 or raise your hand. I don't see anybody, Chairman DeVold.
Okay, thank you.
Mr. Chair, this is Commissioner Bursey. Maybe
Yeah.
it would be helpful if we knew what events were associated with the live entertainment tax that we're talking about.
I think those were the 4 events that Ms. Robeck spoke of. There was a Monster Jam and the National Finals Rodeo events, and I forget the other 2, Ms. Robeck.
Yes, sir. The Supercross and World Cup.
And I think where Commissioner Brown was going was why in the world would the Desert Research Institute be involved in those 4 events? I guess it's a curiosity thing, probably more than anything. Ms. Roebuck, you're convinced that they're the ones that are due this refund and they're the ones that paid it originally, correct?
Thank you, sir. Yes, sir. These are the returns that were filed and that were amended. So these are the taxes that were paid under this account. So this is the same entity that reported them, paid it, and has requested the refund.
Okay.
So it's not a case of Desert Research Institute coming in and asking for a refund on behalf of these locations that are not part of their that were not originally reported.
Ms. Hughes, could you do something for us? Could you help us understand why the Desert Research Institute would be involved in these? Maybe an agenda item for the next, or in your executive director report at the end of the next tax commission meeting. Could you help us understand?
Yes, Chairman.
Thank you. You're very kind. Any other questions of Ms. Roebuck?
Just to weigh in, I think we all know that these facilities are used for a myriad of different events, but I do find it curious how DRI is the conduit. And so the tax returns themselves actually have Desert Research Institute as the taxpayer?
Thank you, Commissioner. The returns themselves have the DBA of each location. And, I'm looking at the letterhead and I'm trying to kind of see if there's a way to determine how these are all related. And on the letterhead, it does have Thomas and Mack, Sam Boyd Stadium, Cox Pavilion, UNLV tickets, perhaps, Thomas and Mack Center. So it does appear that they are all related in some way or another. I'm sorry, I don't have the in-depth relationship in front of me.
Right. So, but I do appreciate Chairman asking Director Hughes for some clarity, but we can see how this could be a complicated series of entities. So anyway, thank you. I would move, is it appropriate for me to make a motion now? Yeah.
Yes, please.
Thank you. I would move to approve the refund credit request of Desert Research Institute. Basically, they're just repaying monies they already paid back because these events didn't happen. So thank you.
Commissioner Bursey seconds.
Okay, thank you.
Mr. Chairman?
Yes.
I apologize. I'd like to make a disclosure and ask for Ms. Bordelove's direction. My son is a student worker at the Nevada System of Higher Education. He's a receptionist part-time while he's attending college, and the Desert Research Institute is part of the Nevada System of Higher Education. So if I need to excuse myself, I'm happy to do that, or whatever her advice is.
Thank you, Commissioner Brown. Just to clarify, you said your son is a student at UNLV. Is he affiliated with Desert Research Institute itself or just UNLV as a whole?
I'm sorry, Ms. Bordelove. My son is a student worker.
Okay.
He goes to the University of Nevada, Reno, but he's a student worker and his employer is the Nevada System of Higher Education. So he works in the Chancellor's office, and DRI is part of the System of Higher Education.
I think a disclosure would be sufficient, but if you feel in any way that you can't be impartial in this decision, you could recuse as well. And I think there are plenty here to cover quorum and make the decision if you choose to recuse.
Great, I appreciate that. I'll excuse myself and abstain. Thank you.
Then Chairman DeVold, perhaps as everyone does know, I'm a law professor at UNLV, so I definitely am an employee of NCHI. So I will ask for someone else to make the motion, but I do feel confident I can be impartial. But I feel we're all in good hands without Commissioner Brown or myself.
I agree. Would someone else like to make the motion, please?
This is Commissioner Bursey. I move to approve the refund request of Desert Research Institute.
Commissioner Witt, second.
Okay, I've got a motion and second. All those in favor, please signify by saying aye.
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 Anyone opposed? And I've got 2 abstentions, correct? Commissioner Littman.
Correct.
And Commissioner Brown. Okay, so the motion passes. I want to applaud the Desert Research Institute for paying live entertainment tax, by the way. I think that's wonderful and very much appreciated by all the taxpayers in the state of Nevada. Director Hughes, next item on the agenda.
Yes, the next item on the agenda is 5B3, Rocky Mountain Hospital and Medical Service, Inc. And for the department, we have Brandon Mackey. Brandon, if you're on the telephone, please dial *9. Okay. Brandon should be available. He is unmuting, I believe. Brandon, you may need to dial *6 to unmute yourself. There we go.
Good morning. My name is Brandon Mackey, Tax Program Supervisor for the Department of Taxation. Can you guys hear me?
Yes, we can. Brandon, could you spell your last name for the record, please?
Yes, sir. For the record, it is Mackie.
Thank you. Go ahead, please.
The Department of Taxation is recommending approval of a credit refund in the amount of $382,894.35 for the overpayment of insurance premium tax by Rocky Mountain Hospital and Medical Services, Inc. After processing the taxpayer's reconciliation return for the 2019 tax year, the department reviewed and verified the taxpayer filed and paid the quarterly insurance premium tax returns timely during that 2019 tax year. However, the taxpayer overreported and overpaid and included premiums which were not subject to insurance premium tax on the December 31st, 2019 return. This discrepancy was discovered by the taxpayer when they filed their annual reconciliation return in 2019. And as a result, the December 31st, 2019 return, the liability was reduced, resulting in an overpayment and a refund request in the amount of $382,894.35. I'm available for any questions that you guys may have.
Thank you, Mr. Mackey. Any questions?
Mr. Chairman, Commissioner Byram, does it doesn't look like this includes interest. Is that, was there a reason for that, or does it?
On this particular tax type, there is no interest that is refunded.
Okay, thank you.
Is there a motion to approve the refund?
Mr. Chairman, Commissioner Byram,
Brown.
I would move to approve the refund to Rocky Mountain Hospital.
Commissioner Brown, second.
I've got a motion and second. All those in favor, please signify by saying aye.
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 Anyone opposed? Okay, refund is approved. Director Hughes, next item.
Yes, the next item is 5C, Taxpayers Appeal of Administrative Law Judge's Decision pursuant to NRS 360-245 and NAC 36175. The first item on the agenda is I Purchase Online, DBA Vape Society Supplies. We have Hillary Bunker representing the department, and the taxpayer is on Zoom.
And I believe we heard from the taxpayer that he is online now. Is that correct?
Yes, good morning. This is William Gonzalez for the taxpayer.
Thank you, Mr. Gonzalez. Ms. Bunker, are you online as well?
Good morning, this is Hillary Bunker. I'm on Zoom.
Okay, thank you. Could you go ahead and make the presentation on this?
Certainly, this stems, Hillary Bunker for the record, this stems from a seizure that the Department of Taxation performed on March 25th, 2021. The appellant in this case is I Purchase Online, and despite being advised on numerous occasions to obtain the proper tobacco licensing, they failed to do so and continued to operate both purchasing and selling vapor products for approximately 15 months without obtaining licensing or paying taxes or submitting returns. So in March of this year, the department went out and performed a seizure, seized the products on site, and we held a hearing before an administrative law judge in April. I will note that the hearing officer upheld the department's seizure as lawful and overall found that the appellant had completely disregarded Nevada law both before and after the department seized product. The appellant admitted on the record at the hearing, and it was also confirmed by the investigator, that after the product was seized at his warehouse, the seizure stickers and shrink wrap were removed and product was continued to be sold despite it being seized on site and the property of the department at that time. Ultimately, after the ALJ upheld the department's seizure, as the product was still on site, the product that had not been sold, the parties agreed that the department would come and pick the product up on May 17th, which was a Monday. As you'll note from the department's brief and emails and pictures, the taxpayer took it upon himself to place all of the product on a loading dock outside of his warehouse around midnight the night before the department was to arrive. When the department arrived at 8 a.m. on the agreed upon day, all of the product was missing. So in the event the tax commission chooses to reverse the hearing officer's findings, the department cannot actually return any product as the product is missing currently and the department has never had it in its physical possession. So I'm here to answer any questions after the taxpayer presents.
Thank you, Ms. Bunker. Mr. Gonzalez, could you state your case for us, please?
Yes, good morning, Mr. Chairman and the commission members. I will not dispute any of the facts raised by Ms. Bunker. Those are all completely true. What we believe, Your Honor, is that the seizure order was erroneous and contrary to the public policy of the state, as a seizure order was the equivalent of giving a death penalty for a low-level offense. I Purchase's business has been destroyed, and dozens of Nevadans has lost jobs beyond this. Although the state may contend that I Purchase was not in compliance with the law prior to the state licensure requirements, they were. They paid all their applicable fees, they had city licensure, and was otherwise a properly tax-paying business. And it's not unreasonable to assume that if they had timely applied for the state OTP license, they would have been awarded that license. Mr. Chairman, public policy looks to equity and promoting the public good in the state of Nevada for its citizens. And I pose the question is, how is the seizure order equitable and promote the public good in the state? This valley has been absolutely decimated by the virus, and we're now just starting to turn around, even with the Delta variant. Businesses are opening, individuals are getting back to work, and things are turning around. Your Honor, I Purchase acknowledges that they didn't have a state license, and there were some discussions leading up to the need for an application, but there was never a fine issued. There was never a temporary suspension of licensure. I Purchase got the death sentence, which was absolutely unwarranted in this situation. Multiple steps could have been taken prior to the seizure to ensure compliance. or take an affirmative step to get that licensure. The tobacco licensing laws were enacted by the state legislature to ensure that the state and local municipalities were receiving funds, that nobody was selling these OTP products or the cigarettes out of their garage or the trunk of their car. That's not what I purchased did. I purchased operated as an OTP seller for 6 years, 5 years. They did everything correct. The lack of state licensure alone should not be grounds for the business to be absolutely decimated and ended. Mr. Chairman, Ms. Bunker raised some important issues that I would like to address as well. First, regarding the product that had the seizure stickers removed and the shrink wrap. Appellant contends that was a mistake on the weekend crew, and that was just due to a miscommunication on their end. Second is the product that was placed outside of the facility when the department came to pick it up. Ms. Bunker's brief raised some sort of implication that maybe appellant had an idea of where it is, but I'll tell you, we don't. The product was gone that morning. We have no idea where it is, and we acknowledge that the state does not have this product in their possession to give back. It's our hope that if this seizure order is overturned, that iPurchase can go forward, apply for the proper state license, apply for the proper city license, and continue business as a normal course, be a well-paying, tax-paying business, and employ Nevadans. In conclusion, Mr. Chairman and Mr. Commission, we ask that the seizure order be overturned to allow iPurchase to apply for state licensure and be in full compliance in the state and city level and continue to do business in a matter of due course. Thank you. And I'm available if you have any questions as well.
Thank you, Mr. Gonzalez. Ms. Bunker, do you have any rebuttal? And I'll provide Mr. Gonzalez the same opportunity.
I do. Thank you. Hillary Bunker for the record. And I know that appellant has argued this in their hearing brief to the commission, that there were multiple steps that could have been taken, that this was the equivalent of the death sentence. And the department agrees that there were multiple steps that could have been taken. And the fact that the appellant failed to take any of them makes this even more egregious. This was presented before the hearing officer, but before the law came into effect in January of 2020, this was back in November of 2019, the department actually went in person to the taxpayer, informed them that the law was going to be changing, that vapor products were going to be taxed as other tobacco products, and they would need to obtain a license. That was done in person. Following that, in December of 2019, the department had another phone call with a representative from the department, again informing them of the upcoming requirements taking place in January. That was followed up with a letter. That was 3 different occasions. The taxpayers still failed to get a license throughout 2020 when the law became in effect, also failed to obtain a license in 2021, and continued to operate without the license, without paying taxes, without submitting returns until the product was seized. I understand the argument that this was a weekend crew that cut the labels off, the seizure labels, destroyed the shrink wrap. The hearing officer did not think that that was persuasive testimony. And I'll also add that in addition to product being sold that had seizure stickers on it and was wrapped up, the appellant also continued to receive product. And we were able to present that at the hearing, that they continued to purchase product as a wholesale business, even after the product was seized. So if the commission wants to agree and say perhaps it was a weekend crew that was unsure what the shrink wrap or seizure stickers meant, you still have the business itself purchasing product tax unpaid. And unfortunately, we cannot agree with the statement that absent getting a license, this business was in compliance otherwise. This is a license that is regulated. It requires a fee. And as mentioned, we're not discussing currently the failure to file tax returns, the failure to pay OTP taxes, but simply obtaining a City of Henderson license does not put you into compliance with the state, and they were not in fact in compliance with all of the state licensing requirements.
Thank you, Ms. Bunker. Mr. Gonzalez, do you have a final rebuttal before I bring it back?
Of course, I will be extremely brief. Ms. Bunker's statement about the handout and the department visiting in person is correct, and we don't dispute that. However, it is our position that a simple in-person visit with a handout is simply not enough. And if that's the only step that needs to be taken before a business can be destroyed in the state, it doesn't feel right. you know, you have that gut feeling and it doesn't feel right to you, there should be some fines. There should be a temporary licensure with every other type of licensed product, whether it's a bar license, for instance. The bar can come and suspend me temporarily. Your Honor, this company had a state license for years. I'm sorry, not a state license, a city license for 5 years with no issues whatsoever and was fully operating within the law. So if there's any sort of implication that if an application was submitted at the state level and it would have been declined, we would also have been appealing that decision as well, but that's not why we're here today. Mr. Chairman, the wholesale purchases were also made a mistake due to the belief that we were operating correctly under the law and that the city license constituted a state license. It was simply a misunderstanding, and a misunderstanding should not be grounds to end somebody's business and put people on the streets. Mr. Chairman, that's all I have. I just urge you to take a look at all the factors. Both parties presented fine arguments, and I just urge you to give this business another shot and give them the opportunity to act in the right way, and they will do so in the future. Thank you.
Thank you, Mr. Gonzalez. I'll bring it back to the Tax Commission now. Are there any questions of the taxpayer or the department?
This is Commissioner Witt. I would move to approve and support the department in the decision versus I purchase online.
Commissioner Bursey seconds.
Yeah, I've got a motion and second to uphold the administrative law judge's decision pursuant to NRS 360.245 and NAC 360.175 regarding I purchase online DBA Vape Society supplies. Is there any other discussion?
Mr. Chairman, I do have a few comments I'd like to make, please.
Yes, please.
Commissioner Brown, I would just point out that there are a couple aspects to this case that were troubling to me. The taxpayer was not truthful with the department on several occasions, one of which, when the department appeared and contacted the taxpayer, he said no one was at the business when the department had seen employees inside the business. And ultimately, the department was let into the business, and there were, in fact, roughly a dozen employees inside of the business. On a second occasion, the department contacted the taxpayer for access to the building, and he said, "I'm out of town. I can't come in. I can't let you in." And shortly thereafter, the same contact, the taxpayer arrives. So I do have some trouble with the credibility of the taxpayer and the way he represented himself in front of the department.
Thank you, Commissioner Brown. Any other discussion items?
This is Commissioner Bursey. This just absolute curiosity. I understand the contraband was placed outside of the warehouse to wait for the department to come pick it up. Were those products put in a secured area outside the warehouse?
Hi, Commissioner Bursey. This is Mr. Gonzalez for iPurchase. They were just located outside of the warehouse as the landlord was told that they had to not evacuate, but essentially relieve themselves of the purposes, so they had to remove all their product outside.
So it was not just the product that was seized, it was all the products in the warehouse, in the business?
I am not sure. I can't answer that question.
Okay, thank you.
Thank you.
Any other discussion? Okay, I've got a motion and second on the floor. All those in favor, please signify by saying aye.
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 Aye. Anyone opposed? Very good. Administrative law judge's decision is upheld. Let's go ahead and take about a 5-minute break, and we'll be back at 10:45.
Puppies, come get your treaties. Okay, who's gonna be first? Me first? In a second. How about you? There you go. There you go, good kids.
Good.
Oh, and your microphone is on.
It was. I just muted her.
Okay, I've got 10:45. Let's go ahead and get started again. Director Hughes, the next item on the agenda are all of the, hold on, please. All right, it looks like we've got everybody back now. Director Hughes, go ahead with the next item.
Yes, the next item is 5C2, Flex Ground Nevada LLC. For the department, we have Natasha Gabriel with the Attorney General's office. And I believe the taxpayer is on the line.
This is Andrew Glendon, representative of the taxpayer, if you can hear me.
Yes, Mr. Glendon, we can hear you. Mr. Glendon, this is your appeal of an administrative law judge's decision. Go ahead and make your case, please.
Sure. Good morning, Mr. Chairman and Commissioners, and thank you in advance for allowing me to present this matter. I represent Flex Ground Nevada LLC, the taxpayer, Mr. Corey Haig, the taxpayer's representative, I believe is also in attendance. For the record, my last name is Glendon. The briefing on this matter was fairly extensive, so I'll try and be brief this morning. The summary of the matter is as follows. Play It Safe is an equipment retailer that was registered with the Department of Taxation as a retailer, delivered equipment into Nevada. The 9 or so equipment purchases at issue, which pursuant to the regulations means that the sales of that equipment took place in Nevada. Play It Safe had a local salesperson that resided in Nevada, and the terms of the sales at issue were all negotiated in Nevada. The taxpayer was not charged sales tax by the retailer on the purchase of its equipment from Play It Safe. I'll get into in a second is that there was some confusion, I believe, between all parties involved as well as the industry in general as to the nature of these transactions, and presumably that's why sales tax was not charged. Because of that, the department is trying to charge the taxpayer use tax on these equipment purchases. This is improper because use tax is applicable to out-of-state purchases of equipment or materials that are then stored, used, or consumed in Nevada. The use tax is not applicable to in-state transactions. The department argues that the taxpayer should have paid sales tax on the purchases, and because they didn't, then the department can charge use tax. This is an improper, ends justify the means analysis and is in error. There's a specific exemption that applies in addition to it being an improper charging of the use tax. There's an exemption that applies when sales tax should have been charged such that the use tax can't be charged. The department has specific authority to administer the Sales and Use Tax Act as it's written, but no authority or ability to change the act in order to impose taxes that it deems to be proper. And this is what the department's trying to do in this case. The commission has the authority to reverse the decision of the hearing officer if the decision is either affected by an error of law, is clearly erroneous, or is arbitrary, capricious, or characterized by abuse of discretion. The decision in this matter should be reversed on all three of those grounds. Again, briefly, the error of law in this case is that the decision was based on the determination of the hearing officer that the testimony of Mr. Corey Haig was hearsay. This is improper. Hearsay, by definition, is an out-of-court statement that is offered to prove the truth of the matter asserted. That's the law school definition. The testimony of Mr. Haig was not hearsay. He was testifying under oath at a hearing. His testimony was based on his own personal knowledge of the business of Play It Safe. Specifically, Mr. Haig testified that, and his testimony was based on the fact that the taxpayer was in business with Play It Safe from its inception in around 2015, so for more than 5 years. And the industry in which the taxpayer and Play It Safe compete is a small industry where they work together often and the parties know of each other's business. Because of this, the testimony of Mr. Haig should have been admitted or considered by the hearing officer, in addition to the fact that is already in the record that Play It Safe was a registered retailer in Nevada and that delivered the equipment at issue into Nevada. Having the improper determination of hearsay would also put into the record the conclusion or the testimonial evidence that Play It Safe had a salesperson located in Nevada who negotiated all of the transactions at issue in Nevada. Clearly, all of this evidence is that Play It Safe was a Nevada-based retailer for the transactions at issue, and the determination of the decision that the testimony of Mr. Haig was hearsay is an error. Because of this error of law, the decision is clearly erroneous as it's based on a faulty premise. Again, the decision was based on an improper determination of hearsay testimony. When you admit, or because that evidence was improperly not considered, when that's taken into account with the rest of the evidence, it clearly, again, demonstrates that Play It Safe was a Nevada-based retailer and had the obligation to collect and remit sales tax. In addition, the commission should consider that the department failed to investigate the business of Play It Safe whatsoever. The department had at least 2 discussions with Play It Safe during the petition period, but didn't inquire as to the principal place of business of the company, didn't inquire as to any meetings that may have been based in Nevada or the location of its salespersons, didn't inquire as to the volume of business in Nevada by Play It Safe. It appears that the department's sole purpose in these discussions was to coordinate the production of an after-the-fact retail sales certificate, which was what the revised determination was based on, but the decision correctly concludes that that wasn't even relevant. As such, the decision should be overturned based on the clearly erroneous standard. Finally, the decision can also be overturned as being arbitrary and capricious. The initial determination was based on the erroneous conclusion, erroneous for the reasons that I just stated, that Play It Safe was an out-of-state retailer. On the petition for redetermination, it was asserted the facts that they were not out of state. And then all of a sudden, the revised determination was based on the purported existence of a retail sales certificate, which again, the decision refuted. So there was a completely 180 degree alteration of the basis for the determination. There were discussions with the department about the retail sales certificate. It was explained that this was provided and intended to apply only to future transactions, but the department didn't consider that in connection with the revised determination. The decision then, again, was based on, after refuting or agreeing that the retail sales certificate had no bearing on the matter, based its conclusion, again, that Play It Safe was an out-of-state retailer, which again was based on the error of law regarding the testimonial issue, evidence at issue. Separately, as part of the petition for redetermination, the taxpayer is contesting the charge of all the interest and penalties as well. The record demonstrates that any failure to remit sales tax was an innocent mistake in this matter, and the interest and penalty are being contested both as to the remaining deficiency, which again is the tax claimed to be owing on 9 specified equipment purchases, but we have also petitioned or are contested the interest and penalty as it relates to the entire deficiency determination. And I note for the record, the uncontested portion of the tax was already paid by the taxpayer and was based on a determination relative to kind of a different facet of the taxpayer's business. The record evidences that any failure to collect and remit taxes was based on a reasonable determination that the taxes were not owed. Tax-exempt information was provided to the taxpayer by its customers, which were generally nonprofit entities. And there's evidence in the record that there's an understanding of the industry in general that sales tax is not owing on transactions such as those in this matter. The department indicates that the only reasons interest and penalty can be overturned is due to fire, flood, death, things that I would characterize as classic cases of force majeure. But the regulations are not so limited and allow for interest and penalty to be overturned due to circumstances beyond the taxpayer's control that occurred despite the exercise of ordinary care and without intent. There's no intent to avoid taxes in this matter. The taxpayer not only paid the uncontested tax amount, but it also modified its business practices to now start taking into account sales tax that would be owing on future transactions such as this and those matters, and make sure that those are accounted for in its bidding practices. And the failure to remit taxes was based on information received from its customers, and again, was also the understanding of the industry. And there's also testimonial evidence that this was the practice in other jurisdictions in which the taxpayer operates. And all of this confirms that there was no intent for the taxpayer to avoid taxes in this matter, and interest and penalty should be overturned. In conclusion, the commission has the authority and should overturn the decision. It was based on an error of law, as we discussed. And that's all I've got. Thank you, and I'm available to answer any questions.
Thank you, Mr. Glendon. Ms. Gabriel, do you have a response?
Yes, Chairman, thank you. And thank you, Commissioners. You can all hear me, is that correct? Just confirming, great. The department moves for this commission to uphold the ALJ's decision in its entirety for 3 reasons. The first reason is that under Nevada law, it was flex ground that bore the ultimate responsibility to pay this tax on these 9 transactions. The second reason, that's whether or not Play It Safe was a Nevada company or an Arizona company. Second, even if this commission would consider whether or not Play It Safe was or was not a Nevada company, during the hearing, FlexGround failed to establish that Play It Safe was a Nevada company and had sufficient nexus so that the department can go after them for these transactions. And thirdly, what FlexGround is not entitled to a waiver of penalties and interest because it did not exercise ordinary care in determining whether the taxability of these transactions. Going to my first point, under NRS 372-185, our use tax applies to the use, storage, and consumption of tangible personal property in our state. Although the use tax usually applies to transactions that occurred outside of Nevada, that it is not exclusively for that purpose. And the Nevada Supreme Court has held such in the Nevada Cement Company case in 2000. It says that use tax complements the sales tax so that all tangible personal property sold or used in our state is subject to our sales tax or use tax. Furthermore, in Southern California Edison case, a 2017 Nevada Supreme Court case, the court stated that the responsibility to pay use tax is on the party that made the purchase and used the property in our state. Next, turning to construction contractors. FlexGround in this instant was a construction contractor under NAC 372-190 sub 2, which states that any person who acts solely in his professional capacity or through others to construct, alter, repair, add to, remodel, or otherwise improve real property is a construction contractor. And under NAC 372-200, we see that construction contractors are consumers of tangible personal property for use in improving the real property, and the tax applies to the total sales price of the property to the contractor. NAC 372-200 sub 2 states that the use tax applies in instances where sales tax has not been paid. So we see here that reading our regulations and the case law together, we see that the contractor is ultimately responsible for tax on any construction materials or equipment because the retail sale was between the contractor and the supplier, not the contractor and the project owner. And the transaction is not between the contractor and the project owner. And that's because once the project owner acquires realty from the contractor, not tangible personal property. Once the materials and the equipment are utilized to improve the realty, they lose that character as tangible personal property. And that was also in ALJ Smith's order in this matter. And then we turn to NRS 372-340. When a contractor buys or consumes tangible personal property to fulfill a government contract, the contractor must pay taxes on that purchase unless they are a constituent part of that entity. FlexGround here, although they were fulfilling government contracts and were operating under the assumption that they were tax exempt because it was filling a government contract, our statutes explicitly state that that is not the case. Had some ordinary care been exercised, FlexGround would have been alerted to this. There was no indication in the record that there was any exercise of ordinary care. FlexGround did not testify that they looked to the department or asked the department for advice on these types of transactions, nor was there evidence that they sought advice from another tax professional on the taxability of these transactions. In fact, the only testimony was that they contacted Clark County District Schools and inquired as to the taxability based on the tax exemption letters that they received from the district itself, and the district did not advise FlexGround. They merely stated that it was up to them to determine the taxability of these transactions. FlexGround then just determined that they were not taxable, and that just wasn't the case. ALJ Smith looked to evidence at the hearing, and those were estimates that stated that they were a resale and no tax. Those estimates, then the corresponding invoices to those estimates had the same total amount with no sales tax paid. And it also, so it was a correct conclusion that at the time that these transactions were made, FlexGround did not intend to pay sales tax. They were operating under the belief that they were tax exempt, but again, had they or exercised ordinary care, they would have found out that they were in fact taxable, and it was their responsibility to pay the sales tax. If they didn't pay the sales tax, it was their responsibility to then pay the use tax. It was incorporated so therefore, because the equipment was incorporated onto real property, and it was incorporated onto real property subject to a contract with their customers, it was not a retail sale. And so sales tax, and because sales tax was not paid at the time of purchase, FlexGround remains responsible for this tax. They made the purchase and they utilized the property in Nevada, not Play It Safe. So whether or not Play It Safe is an Arizona company or a Nevada company, that does not matter for purposes of these specific transactions. They were purchased by FlexGround as equipment. FlexGround was a construction contractor. They were responsible to pay, if they didn't pay the sales tax, they were responsible to pay the use tax. And that's how it was assessed. Now, so even if Play It Safe is a Nevada retailer, FlexGround still bears the responsibility. However, during the hearing, there was testimony by Mr. Haig that Play It Safe may have been a Nevada company. And the judge considered this evidence. It's not that she didn't consider it, but the hearing officer is the ultimate fact finder. And as the ultimate fact finder, she did not find that testimony credible in comparison to looking at how Play It Safe is registered. They are registered in Nevada as a foreign corporation, and they list Arizona as their jurisdiction and an Arizona address. They are registered with the department, and they are registered with the department as having only an Arizona address. Judge Smith looked at these items in conjunction with the testimony and ruled that without the testimony failed to corroborate that Play It Safe had a sufficient nexus for her to determine that it was a Nevada company. But nevertheless, whether or not, again, it was a Nevada company doesn't matter for taxability of these transactions and who's responsible for the tax on these transactions. Thirdly, there is no evidence that FlexGround sought guidance, again, from the department or another tax professional. And had they conducted a reasonable search of both our regulations and our statutes, they would have at least come across NAC 372-200 and NRS 372-340, which states that construction contractors are the consumers of tangible personal property. And if they don't pay sales tax at the time, then they are responsible for the use tax of the property if they use it in our state. And then they would have seen 340, which stated that even if you are fulfilling a government contract as a government contractor, construction contractor, you are still a consumer of tangible personal property, and you are still responsible for that tax unless you are a constituent part of that entity. So they have failed to show that they are entitled to a penalty, to a waiver of any penalty and interest, in addition to waiver of any of the deficiency. Because again, had they exercised some ordinary care, these statutes existed, these regulations existed, they would have seen that, they would have made a different determination as to taxability, and we wouldn't be here today. And with that, I am available for any questions that the commission may have.
Thank you, Ms. Gabriel. Mr. Glendon, do you have a response?
Hello, can you hear me?
Yes, I can now. Thank you.
The screen readjusted and it looked like I was no longer part of the hearing. Thank you. And again, I'll be brief. As to the last point regarding the failure to investigate, the department, right, asked the question at the hearing numerous times and again has indicated that, well, the taxpayer just could have opened up some regulations and come to some conclusion regarding its taxability. I think that's an error. Again, the taxpayer in this case relied on industry standard and it was generally understood in the industry as to these transactions are not taxable. And even Ms. Gabriel pointed out that there was inquiries of some of its customers. And I just correct the record to say that first, the answer that the taxpayer got was no, the transactions aren't taxable. And then later, the customer came back and clarified that the taxpayer may want to, make its own determination as to those issues. The Nevada Supreme Court has stated that the Sales and Use Tax Act must be construed in favor of the taxpayer. This is because this area of tax law is plagued by uncertainty and inconsistency. So the statutes and regulations must be construed in favor of the taxpayer. So I point out that I don't think it's as easy for a taxpayer to just open up the regulations and come to a conclusion. In terms of the taxpayer ultimately bearing the tax, I believe that this is an error. It is clear that the sales and use tax are complementary. But if a taxpayer purchases something from a Nevada retailer, the obligation is clearly on that retailer to collect and remit tax. To determine otherwise would have every single taxpayer that makes a purchase at Home Depot or any other retailer potentially subject to a use tax audit and reporting if for whatever reason those transactions failed to become taxable. Say there was a error in a SKU code and a taxable piece of merchandise came up as untaxable. That's not correct. They're complementary in that either way the department is supposed to get taxed. If it's purchased, if the same piece of equipment is purchased from a Nevada retailer, sales tax is applicable. If it's purchased from an out-of-state retailer and then stored, used, or consumed in Nevada, it's subject to use tax. And in fact, there's an exemption, NRS 372.345, which specifically says the gross receipt from sale of property that are required to be included in the measure of the sales tax are excluded from the use tax. The decision indicates that a retailer's failure to collect the tax from the customer does not necessarily extinguish the retailer's liability for the tax, but then it cites to a few statutory provisions, which I've included in Schedule 1 of my brief because I thought they were important, none of which stand for that proposition whatsoever. I agree with Ms. Gabriel as to the courts construing the sales and use tax as complementary, but again, I caution that at no time have they concluded that a use tax is applicable on a Nevada-based transaction. The final point raised by the department is that FlexGround, the taxpayer, failed to establish a nexus of a third-party taxpayer. Play it safe. This is not the obligation of the taxpayer. The taxpayer did introduce evidence as to where the transactions occurred, that Play It Safe had a local retailer, that again, the equipment was delivered into Nevada, making it by regulation a Nevada-based transaction, and the department completely failed to investigate Play It Safe whatsoever. In answer to the question as to whether there's any other evidence other than an Arizona address to support your finding that Play It Safe was an out-of-state vendor, the department confirmed no. In answer to the question as to what evidence is there other than the address of Play It Safe to support that they're an out-of-state vendor, the department said just the invoices, the same invoices from Play It Safe. This reference to invoices are invoices that aren't even in the record. It was some sample invoice that was collected in connection with the initial audit. In answer to the question whether the auditor had any discussions with Play It Safe relative to them having an in-state salesperson that resided in Nevada, the department answered, I cannot remember. In answer to the question whether the auditor had any discussions with Play It Safe relative to their delivery of the equipment at issue into Nevada, the department answered, I cannot remember. In answer to the question whether the auditor had any discussions with Play It Safe regarding the meetings giving rise to the transaction at issue occurring in Nevada, the department answered, I cannot remember. In answer to the question whether the auditor had any information relative to the amount of transactions that Play It Safe transacts annually in Nevada, the department answered, I cannot remember if I checked that information. So again, the argument of the department is that the taxpayer FlexGround somehow had the obligation, which is not set forth in the Sales and Use Tax Act, to establish a nexus with a third-party taxpayer. Again, that's an error, but the department woefully failed to conduct any investigation, and there is ample evidence, again, assuming that the error of law is overturned and excluding improperly the testimonial evidence characterized as hearsay, that Play It Safe was in fact a Nevada retailer and had the obligation to collect and remit sales tax. Thank you.
Thank you, Mr. Glendon. Ms. Gabriel, do you have any follow-up comments before I take it back to the commission?
Yes, thank you, Chairman. I would just like to point out that there wasn't a failure to investigate whether or not Play It Safe was or was not an Arizona company at the time that these transactions were being analyzed by the auditor on audit and redetermination. Her main questioning for Play It Safe were the resale certificates. So what was brought to her attention were those estimates and then corresponding invoices that say at the end there that they are resale no tax. And so her first call was, hey, I don't see a resale certificate. Why does this state this? And that was the line of her questioning. As we've learned, as we've gone on, and again, though that resale, there were questions about whether or not Play It Safe had a resale, and then it was backdated, or sorry, future dated. And so there were many issues with that, even at the hearing. And ultimately, ALJ Smith decided that the resale certificate, whether or not it was misused or not, really wasn't relevant to the legal analysis here, which was ultimately that FlexGround is a construction contractor, that they purchased equipment to fulfill a contract. They were the consumers of the tangible personal property, no sales tax paid at the time, but property is used in Nevada, therefore use tax applies. That was the line of reasoning, and that is the department follows that reasoning. The auditor wasn't necessarily looking to, is this truly a Nevada company? Is it an Arizona company? Her main concern was, and she testified to this, that construction contractors, she very, very rarely sees resale certificates, because again, they're not, it's a retail sale between the contractor and its vendor, yes, but it's not for resale. They're not reselling that playground equipment. What they're doing is they're installing it onto real property, and it loses that tangible personal property, that status, if you will. And so because it loses that status, that's not a taxable transaction between the contractor and the project owner. And so a resale certificate does not apply there, because it's improper, it's not a resale. Okay, so if it's not a resale, but tax wasn't paid, now use tax applies. Even in cases where we see a retailer that purchased something for resale, but then pulls it out of their inventory and actually utilizes it, they are then to pay use tax on that property because they did not resell it at retail. So that was a line of questioning, and I just wanted to clarify for the record that there wasn't a failure by the department to not investigate whether this was an out-of-state retailer. Her main concern at the time was because she saw resale, no tax. That was her line of questioning. And we know now, ALJ Smith, that's it. Once she considered that, she found it irrelevant to the argument altogether. And I just kind of wanted to clarify that for the commission. Thank you.
Thank you, Ms. Gabriel. I'll bring it back to the commission now. Are there any questions of the taxpayer or the department at this time?
Mr. Chair, this is Commissioner Byram.
Go ahead, please.
I have a lot of thoughts, and I'm not sure it's going to turn into a question, but I am kind of curious of why so much time was spent trying to determine whether or not there was a nexus with Play It Safe, when the question about nexus is whether or not the state of Nevada can exercise jurisdiction over them. They submitted themselves to become a vendor in Nevada by registering for to be a retailer of tangible personal property in the state. So that wipes out that whole question. They've submitted themselves to have nexus, and there isn't any question or need to look into whether they're physically located in Arizona or anywhere else. They're selling into Nevada. They made that analysis somehow internally and registered as a Nevada vendor. So they are a Nevada vendor for all intents and purposes for this transaction. The second thing is there's a difference between sales tax and use tax. Having the primary liability is sales tax. The primary liability for collecting it and remitting it to the state is on the seller. But as Ms. Gabriel said, if a taxable item, if the tax was not collected by the seller, then use tax applies. So that's been in probably 35 years of being audited by the state of Nevada, when regardless of whether they accepted a resale certificate or knew it was, or other exemption thinking that this was a sale to the government, or they just mistakenly didn't charge sales tax, the purchaser in the state of Nevada is liable for the use tax. And so I think that there's a lot of argument about something that's just very simple. So there's the sales tax, complementary use tax, primary liability, secondary liability. I don't know if it says that in the statute, primary and secondary. That's just the effect of how it's always been dealt with in the state of Nevada. Now, the vendor, Play It Safe, questioned whether or not they accepted a resale certificate. If there was one presented to them and they accepted it in good faith, then they don't charge the sales tax. But whether or not one was sent to them, they didn't. Had they charged the sales tax, it would have been billed to FlexGround. And since they didn't, FlexGround has to pay it anyway. So as far as what the decision says about the Play It Safe being liable for the tax, yeah, they're liable for the use tax, but it's a pass-through tax. So the ultimate purchaser is the government. And had they factored that in as part of the cost of those items, then they would have been paid back in essence as part of their cost. It's probably too late for that contract, but according to what Mr. Glendon says, they now understand that as a licensed contractor, that they are the consumer of items used to fulfill the contract, and thereby they must pay the sales tax on those items. They pass that on to their government entity. They don't need to call that out on a separate line. That just means that whatever they bought is 8%, cost 8% more than they might have thought it would, because sales tax is included. But it just seems pretty simple to me. I'm a little more concerned about there being some confusion because it was a government contract, but as Ms. Gabriel pointed out, the statutes are pretty clear. And there's a lot of case law. So there's been a lot of confusion, or there wouldn't be a lot of case law on the fact that even if you're fulfilling a government contract, you are the ultimate consumer as a contractor. of those items, and you need to build that into your price. So that's my thought, and I'm supportive of the decision that was made.
Thank you, Commissioner Byram. Any other comments or questions of the taxpayer or the department?
Commissioner, go ahead.
No, you go ahead.
Okay, thank you. Commissioner Littman, I do want to, as a tax law professor, I want to applaud both Ms. Gabriel and Mr. Glendon, and actually Commissioner Byram, you did an excellent job of trying to restate the issues before the commission. I do think it is perhaps not as transparent and as we would all like it to be. Tax law is complicated, sales and use tax are complicated, and when you add a schoolyard and installing product on the schoolyard, I can see how things might get muddied. But I do agree with the ALJ's decision. However, I would like to perhaps suggest that the interest and penalties are maybe not appropriate in this case. I do understand one argument for it, but I think I could be convinced not to go with the penalty and interest assessment. My understanding is the aggregate sales tax liability is about $36,000. Is that correct?
Natasha Gabriel, for the record, yes, that is correct. So the taxpayer has already paid $84,828.99 towards their deficiency that they did not appeal. And so remaining is $38,384.86. And that is without penalty and interest. That's just deficiency.
Great. So I'm thinking about making a motion to uphold the taxes, but not the penalty and interest.
Thank you, Commissioner Littman. Any other comments from the commission? Commissioner Johnson?
Yes, I had a question to Mr. Glendon. As these transactions, as between Play It Safe and Flex Ground, these transactions that we're looking at today, it seems to me that as to those transactions, there either has to be sales tax due or use tax paid. Would you agree with that?
I would agree with you in that the transactions should have been subject to either sales or use tax. I stand by my belief that the authority and the statute do not provide that it's ultimately the consumer that has to pay the sales tax and the use tax if the sales tax is not collected. I've cited to AGO opinions, Supreme Court authority in footnote 11 of my brief. And again, I also indicate that there's an express exemption from use tax when the gross receipts are required to be included in the measure of the sales tax. So with respect, I do believe that when there's a Nevada-based transaction with a Nevada retailer, they are the ones that are obligated to collect, and that the use tax, again, is complementary to that. To your point, I believe, again, my example is that if I buy a piece of merchandise from a Nevada retailer, I should pay sales tax, but the use tax is complementary in that if I buy it from an out-of-state retailer that does not have a nexus with Nevada, has not applied for a sales tax permit, and thus does not collect and remit that, then and only then am I required to pay the use tax. Again, the authority talks about out-of-state purchases as well as other incidents of taxation. And I hope that answers your question.
Well, follow up, because you've indicated that, Play It Safe has the duty to collect the tax, but doesn't FlexGround have the duty to pay the sales tax? And if a vendor accidentally fails to do it, or in this case, what bothers me is that FlexGround in effect told them not to collect it because they submitted the letter of exemption, which I don't think applied, but they submitted it basically saying don't collect the sales tax. So that bothers me that they told them not to collect it. And now they're coming back and saying, well, it was their duty to collect it and they should pay the sales tax and FlexGround should not. So that's,
Oh, sorry.
go ahead.
I don't believe that the record demonstrates that it was Play It Safe that informed, or that the taxpayer that informed Play It Safe what to do regarding the sales tax. Again, to Commissioner Littman's point, there was confusion in terms of this, 5 or 6 year relationship that was between Play It Safe and other and the taxpayer and others in the community. It was the taxpayer that received no tax certificates from its customers. Were those shared as part of the overall understanding as to the non-taxability of these transactions? I believe so, and I believe that's the reason why tax wasn't collected. But again, there was no intentional act of the taxpayer to inform Play It Safe one way or another as to what to do. And again, I go back to my example previously. If I go into Home Depot to buy, whether I'm a contractor or just working on a weekend project, which I hate, but that's just me, at my house, and I'm not charged sales tax for some reason, is it my obligation as the consumer? I mean, I totally agree with you that the transaction should be subject to tax, but if I'm not charged tax, then is it my obligation to correct the retailer or to report use tax? I don't believe that that's correct from a tax policy perspective, or again, the state of the sales and use tax law.
I'd like to just make a comment here, if that's okay.
Yes, Gabriel, go ahead.
Thank you. So we're not talking about me and you going to Home Depot. This was a construction contractor that was in this industry. I feel like you can't say, well, there was an understanding with our business, with our vendors, because we're all in the same industry, that there was this understanding that these were tax exempt. So really, yeah, maybe there's a question of who told who not to charge me tax. But at the end of it, this isn't a Home Depot transaction. Of course, if I go to Home Depot and I'm not charged sales tax, honestly, I probably wouldn't even notice, if I'm going to be honest with you all, because I take my receipt and I don't even really look at it. So I wouldn't really notice as a consumer, but these are construction contractors that are consumers of tangible personal property that are constantly buying these types of items because this is their business. It's not like a DIY homeowner project. I also want to point out that if in fact there was question about whether or not it was taxability, or if there was question as to FlexGround versus Play It Safe, those estimates, and it's FlexGround 90 and then 92 to 93. Two of those estimates were actually signed by FlexGround. And Mr. Haig testified that a reviewing manager, the signing manager, would have reviewed it if he signed it. So they could have easily said, you're putting resale, no tax here, but it's not a resale. I didn't give you a resale certificate, or it's taxable. You need to charge me sales tax. And it's disingenuous to say, well, it's my vendor's responsibility to determine whether or not he's going to collect tax. No, but you just described a relationship where you guys are constantly in business with each other. And so there is this repertoire where you have that conversation. hey, is this taxable? No, it isn't. These are government entities. There is a conversation. It's not me versus Home Depot. It's just not. Thank you.
Thank you, Ms. Gabriel. Commissioner Johnson, were you finished with your questions?
Well, yeah, I would just say I agree with Deputy Attorney General Gabriel. Ultimately, the tax is collected from the buyer. And in this case, the buyer was FlexGround. And even if Play It Safe paid the tax, if that was what happens in the end, is because they failed to collect it, that they end up paying it, it seems to me that they would have a right to go back against FlexGround for indemnification or subrogation, because ultimately it's the buyer who pays the sales tax.
Thank you, Commissioner Johnson. Any other questions or comments?
This is Commissioner Witt. I just kind of felt that given the 5 or 6 year relationship between FlexGround and Play It Safe, that perhaps they should have gotten together and played it safe and asked the department for a ruling on whether these taxes were going to be due or not. And my experience on this commission has been that if more people or businesses would do that, it would make our agendas much smaller and simpler. So with that, I would be willing to make the motion to support the administrative law judge's decision pursuant to NRS 360-245 and NAC 360-175 for FlexGround Nevada LLC.
Commissioner Bursey seconds.
Is there any further discussion or comments? Commissioner Littman, I think you had one.
As I indicated before, I would be open to waiving the interest and penalties, but I am listening to my fellow commissioners, and it sounds like there's a motion and a second on the table. So I'm fine with going forward with that. But thank you, Chairman.
Okay, I've got a motion and second. Any other discussion? Okay, all those in favor, please signify by saying aye.
Commissioner Chairman DeVold, I don't know, was Commissioner Brown trying to say something? I saw his lips moving, but no, were you muted, Commissioner Brown?
Yes, I apologize. It's fine. I was just going to second what you said, Commissioner Littman, that I would be supportive as well of abating the penalty and interest, but I know that's not the motion before us. So thank you.
And you're both free to vote against the motion, obviously, if you're not in favor of that. So, okay, so I've got a motion and a second on the floor. All those in favor, please signify by saying aye.
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 Is anyone opposed?
I would vote no.
I would vote no, and like to move forward with my subsequent motion, but understand if the other motion has passed.
It looks like the other motion has passed, so be that as it may. Okay, very good. Thank you, Mr. Glendon and Mr. Haig and Ms. Gabriel for your time.
Well, that was brief.
Appreciate it. Director Hughes, the next item on the agenda, please.
Yes, the next item on the agenda is item 5D, petition for reconsideration of department's denial of exemption status for organization created for religious, charitable, or educational purposes pursuant to NRS 372-3261. Item number 1, Stagecoach, has been removed. And so the next item is item number 2, Miss Rodeo America. And Andrea Nichols is representing the department from the Attorney General's office, and we have a taxpayer's representative approaching the table.
Good morning. Are microphones on?
Yes.
Yes, they're working perfectly. Ms. Nichols, would you go ahead and present your case for me, please?
Thank you. I think I'm just supposed to do a brief introduction. For the record, this is Andrea Nichols, Senior Deputy Attorney General. It's Nichols. With me is Charlene Bernardo. She's a tax program supervisor from the Nevada Department of Taxation, and that's Bernardo. I hope I have spelled it correctly. And this is Taxpayer's appeal of the denial of a request for exemption as a charitable organization. I think we did a pretty good job of briefing everything. I'd be happy to answer questions, but I think it should be the taxpayer's appeal.
And I agree, but is there anything in here that we haven't been consistent about in denying this appeal? I mean, I've looked at this and I've heard that they want to make an extended presentation, and we have been, I mean, ridiculously consistent on this point, have we not?
Yes, Your Honor. I think that that's the one place that the Tax Commission has been very, very consistent.
And I'm sorry, the person representing Miss Rodeo America is?
Yes, good morning, Mr. Chair, excuse me. Can you hear me okay? I'm feeling like I'm muffled from the mouse. Jessica Prunty on behalf of Miss Rodeo America, JESSICA PRUNTATY, excuse me. Also present via Zoom is President of Miss Rodeo America, Kiki Shumway, and the Executive Director, Gina Linton. Hello. We have briefed this extensively, and you are also in receipt of our exhibits 1 through 24. I attempted to try to streamline this hearing to an extent by offering to stipulate to the omission of exhibits and facts in the record, but we were unable to do that. I would like to move for admission of all of our exhibits so that they are in the record and give you a brief statement and present some testimony from our witnesses, if you will so allow.
You know, here's the problem. You know, we've been very consistent with denying these exemption statuses, and yours is exactly in the place where we typically deny these. You can make the presentations, and I feel like we would be seriously wasting everyone's time. There's nothing new here that we would not decline this exemption status. So, you know, maybe, you know, with the ability to give you some time to do this, you know, I'd love to hear your presentation, but we've been 100% consistent in denying these exemption claims. So do you wish to proceed with your presentation? And like I say, you know, I've heard from staff that this is going to be a 2-hour presentation. That's unacceptable to me. So I'm willing to give you 5 minutes. Can you do this in 5 minutes and give us the high level version, please?
I will do my best, but as you are probably aware, Chairman DeVold, this is our first opportunity to present. This is our evidentiary hearing, as we have not been in front of an administrative law judge to present testimony and documents in support of our exemption request. The department issued a summary denial on the basis that Miss Rodeo America is allegedly not operating in the state of Nevada, and that it does not appear that its purchases of property in Nevada are used in furtherance of its educational and charitable purposes. And that's simply not the case. I would like to proceed. I don't think it's going to take 2 hours, but I have questions of the department's representative, and I also have our 2 representatives prepared to testify and answer any questions that this commission may have as well.
Go ahead and proceed, but like I say, I think all of please don't rehash the documents that we've already seen. You know, the Tax Commission is really good at reading every document that's provided, so please do not rehash documents that you've already submitted as evidence. And
Absolutely.
with that, please go ahead.
All right. And so I assume that all of all the documents are then in evidence. Is that correct, Mr. Chair?
I couldn't tell you which documents constitute.
I submitted exhibits 1 through 24. I don't believe that Ms. Nichols has an objection to those exhibits. I just want to make sure that the record is clear that they are actually part of the administrative record.
They are in our packet.
Thank you very much. Thank you. So just very briefly, Miss Radio America's primary purpose is to promote Western culture and heritage and educate the public on general topics of ranching, farming, the agricultural industry, and the sport of rodeo. All of their actions are taken in furtherance of these purposes. Governor Sisolak has recognized their deep ties with the state of Nevada, and Governor Sandoval on numerous occasions has acknowledged Miss Rodeo America's educational purposes. It has tax exempt status as a 501c3. It's also exempt from Colorado sales and use tax and the Nevada live entertainment tax. The department denied the exemption request on 2 grounds only: that Miss Rodeo America is allegedly not operating in the state and that it's not using this property in furtherance of its purposes that it purchases here in the state of Nevada. And with all due respect, Miss Rodeo America is clearly operating in the state. It conducts its primary business here in the state of Nevada every year. It holds a mid-year meeting in Las Vegas. It holds its pageant in Las Vegas. It has a taxpayer identification number assigned to it by the Department of Taxation. It collects, remits, and submits sales tax from sales of its gift shop that is at its pageant. The department has also argued in its briefs that to be exempt, it has to either a charitable organization or an educational organization must provide a service that would otherwise be provided by the government or subsidized by the government. That is outside of statute. The Nevada legislature has been very careful in crafting its charitable and educational exemption statutes. It has declared that these organizations are to be exempt from sales and use tax, and it's reserved the authority to set the standards. These are standards that are set in law. They cannot be regulated around, they cannot be interpreted around. Thus, the department is prohibited from imposing additional criteria, but that's what it seeks to do here by its suggestion that you have to be providing services that the government would otherwise provide or that the government would otherwise subsidize. What is interesting is that the department never requested additional information from Miss Rodeo America, and it's not treating it consistently with another similarly situated taxpayer, the Reno Rodeo Association, who is and has been exempt from sales and use tax for quite some time. Similar to Miss Rodeo America, the Reno Rodeo Association puts on a 1-week event. It has a similar corporate purpose of promoting Western culture and educating the public on these types of topics and related topics. It has performances, just like the Miss Rodeo America pageant does. It has corporate sponsors. It charges an entrance fee for members of the public and for the participants. These are all very similar to what Miss Rodeo America does in discharging its charitable and educational purposes. The Taxpayer Bill of Rights mandates that similarly situated taxpayers be treated the same. In this case, we believe that all of the documentary evidence that we have produced and through our arguments in our brief, that we have established that in fact, Miss Rodeo America is undisputedly a charitable and educational organization under Nevada law. It is undisputedly discharging its corporate functions when it is here in Nevada, putting on its pageant, and during which times members of the public are educated on ranching, agriculture, and the art of rodeo. Additionally, the person who serves as Miss Rodeo America every year spends significant time in the state of Nevada. She spends a week at the Reno Rodeo, during which she puts on performances every night of the rodeo, during which she educates the public, again, to the general purposes of the organization. And she is also present during the Nevada Finals Rodeo. Would like to call witnesses if you will so indulge me, Mr. Chair.
Mr. Chairman, did you hear her question?
I did, I'm struggling with calling, I think we can stipulate that Miss Rodeo America is a wonderful organization, and I'm sure that's what each one of them are going to do. But, having a week-long or 2-week-long event is similar to conventions that come in and ask us for the exact same thing, is to avoid taxes in the state. And we've treated everybody 100% the same. And so I think we could stipulate that Miss Rodeo America is a wonderful organization. I don't have anything against them, but I think at the end of the day, unless any of the other commissioners have any other comments, I'd love to hear from other commissioners, because like I say, we've been very consistent with this fact that just because you have an event here doesn't mean that you are domiciled here and you benefit a huge portion of our population, which is kind of the hurdles. Having a couple week-long event or a week-long event doesn't qualify. Commissioner Byron?
I would like to ask the state if you could distinguish, I know we want to be consistent in application of the exemption, but can you distinguish the Reno Rodeo Association from this entity and or compare and contrast, and why is one exempt and the other one not?
I'm sorry, but we can't comment on another taxpayer, and and Ms. Bernardo and I actually did discuss it. Neither one of us is familiar with the application that this exemption letter was issued in relation to.
That's really important for this matter, because we're talking about being consistent, and that sounds like a very similar organization and similar activities, one exempt and one not. So it's important for us to know why would they be treated differently.
Well, if you want to continue this matter, I think we could maybe try to pull their application. I think we might want to submit their application materials under seal, because we do have, we are supposed to keep taxpayer information confidential. And, I don't even know if the Reno Rodeo Association applied as charitable or educational. I don't know what kind of services they're providing. My best guess would be that they came under the provide displays or performances of the visual or performing arts to members of the general public. And then how I guess, and again, this is all hypothetical. And since I just have the opportunity, I just want to address that the law does reflect the public policy, and the public policy behind this law is that there has to be some benefit to the community that would justify the loss of tax revenue. And so the law does reflect that public policy. And in fact, Ms. Prunty actually about quoted the statute, I believe, one of the under NRS 3723261 3B for charitable purposes, the sole or primary purpose. Section 2 is provide services that are otherwise required to be provided by a local government, this state, or the federal government. So I don't see how, first off, that's kind of reflective of the policy, but it's also in statute. Ms. Prunty testified, and I'm going to assume she has personal knowledge concerning this other entity that was given a tax exemption. I don't have personal knowledge of it. But this really, really does appear to be a corporate function that benefits corporations and advertises such things as the American Quarter Horse Association, Justin Boots, Dodge Ram trucks. If you look at their Exhibit 4, it's just one advertisement after another. I think I got a little off topic, but I hope I addressed your concern.
And I understand that, and I believe that Ms. Prunty testified that that the Reno Rodeo also has sponsors, and so that doesn't really distinguish. I'm just concerned that we're, 99.9% of your argument is that it's not exempt, consistent with how we deal with those organizations. The only little wrench in that is a similar organization purportedly has an exemption. How is that?
Okay, I believe that, I'm gonna guess Reno Rodeo Association is a strictly Nevada corporation. This is a Colorado corporation that organizes events all over the country because they pick somebody from each state. Those people go to the state of Nevada for a week long, and they have to show their primary purpose is either charitable or educational. They applied as a charitable. They're kind of wiggling on in their brief, well, maybe we're educational. If they're charitable, I would want to see that they are rendering services that benefit a substantial and indefinite class of persons who are the legitimate subjects of charity. I don't see their primary purpose as providing charitable services in the state of Nevada. If they want to be considered as an educational organization, which is not what they applied under, but they kind of suggested in their brief, and now they want to say, okay, we're either you're primarily charitable or you're primarily educational. You're one or the other. I don't know. I would want to see that if they want to be educational, that they're disseminating information on subjects beneficial to the community. And again, the community is defined very broadly. So we've denied it for, I say that the department and then the commission has upheld things that are for just a particular segment. So if you're coming in to educate people about what we have, orthopedic surgeons, I think, hold one every year, or accountants, or I don't know, maybe real estate. We don't see those as educating the community as a whole. And what they're doing for 1 week in Las Vegas or 2 weeks in Las Vegas, it doesn't seem that their primary purpose is charitable. It doesn't seem that their primary purpose either meets the definition of educational. And again, we fall back to the policy argument and how does this benefit the community? The city and the state it's just like anybody else that goes to Las Vegas for a convention. The city and the state have to provide police, fire, roads, sewer, all of that stuff. And there's nothing that's showing a charitable or educational purpose sufficiently enough, their primary purpose, that would justify the loss of that tax revenue.
Okay. Ms. Perney, did you have a response?
Yes, thank you very much, Commissioner Byron. Initially, we have not been wiggling around. Yes, when Miss Rodeo America did apply, they applied as a charitable organization. However, when you look at the facts of this case, it seems to me that they clearly fall in the educational box. And the Taxpayer Bill of Rights requires the department to acknowledge and inform taxpayers if they are exempt. So it doesn't matter what they applied for. What matters is, are they an educational organization or not? And I posit they do. Now, while there may be a disagreement as to whether or not educating the public on topics of Western culture and heritage, the agricultural industry, ranching and farming benefits the community, I posit that they certainly do. And President Shumway and Executive Director Clinton would also talk about the importance of educating the public about these topics. The Western way of life and agriculture, in some aspects, is a dying breed of people. And so the more that we can promote those purposes, and educate members of the public about where our food comes from and the people who work in these industries to provide, that is certainly beneficial to the community. As we've set forth in our brief, Miss Rodeo America does not have events in all these different states. Their only presence, besides having a small little office in Colorado Springs, because that's where their part-time employee happens to live, is in Nevada. We have Governor Sisolak, Governor Sandoval recognizing their deep, deep ties with the state of Nevada. So when they are discharging their corporate purposes, their express corporate purposes, they are doing it in the state of Nevada. We just heard a very lengthy appeal to this body of an out-of-state organization operating in the state of Nevada. This happens all the time. Companies can be incorporated in one state and have operations in other states. Miss Rodeo America is certainly operating here. Why else would they have to collect and remit sales tax for their gift shop? So I feel like the operating in the state, which is actually a criteria tied to the charitable organization criteria under your statutes, is satisfied. Additionally, the property that they purchase for which they're seeking an exemption, which is about maybe $10,000 worth of sales tax each year, is basically food and beverage to put on their event. And that is for anyone who wants to go to anything, whether it's their horsemanship contest, whether they want to see public speaking, whether they want to see interviews, anyone can go. And so that is why they're here seeking this, because they would otherwise use those funds to continue and further and strengthen their educational purposes and actions in Nevada.
Okay, look, I'm sorry, I don't mean to cut you off, but I think all that's been briefed, and I also think that Ms. Nichols for her presentation and her argument, she saw that it appeared to be educational argument that you were making, and she did analyze that and make a determination that it did not fit that criteria. So she didn't fail to look for other ways that your exemption might apply. She did look.
No, she did in her.
Right. Okay.
Yes.
So that was all I had, Mr. Chairman.
Mr. Chairman, I have just a quick question, if you don't mind.
Please, Mr. Wren.
Thank you. And Ms. Pruitt, in reading our 447 pages, I didn't quite understand what the charitable opportunities your organization was providing to the state of Nevada. Could you readdress that quickly for me?
Absolutely.
Since that is your application.
Yes, absolutely, Commissioner Wren. I'd be happy to. Initially, one of the first things that happens when Miss Rodeo America is crowned, when they select that individual, she and her predecessor go to the Children's Hospital in Las Vegas, Nevada, and they spend quite a bit of time with the kids there. They, of course, hand out gifts and do other charitable activities in that regard. But then they also spend quite a bit of time talking about Western culture. Maybe they might take in a saddle, they might take in other items of tack, and just kind of showing the kids and educating them as to ranching, agriculture. I don't want to sound like I'm beating this horse to death, but that's what they do. They also frequently visit Nellis Air Force Base. They invite members of the military to come to all their performances. They have gone to Opportunity Village in the past, Child Haven, various, whatever they could do. And I think they would like to do more. And they would, if they have a little more resources, they would like to go into the various schools in Nevada, whether it's when Miss Rodeo America is up here in the north at the Reno Rodeo. She would love to be able to present. Same thing when they're there present during the NFR as well.
Okay. All right. Thank you. Thank you, Mr. Chairman.
Thank you, Commissioner Wren. I'm one of the big sponsors of the Reno Rodeo, and they constantly send me details about Levi drives, shoe drives, coat drives, things that they do all year long. So and they bank locally, they have offices locally, they do a lot of things, Commissioner Byron, that they do college scholarships for kids. They do the exact same thing that Miss Rodeo America is attempting to do regarding ranching and farming and things that are probably very near and dear to Commissioner Witt and myself, as I grew up in Yerington on a ranch, working on a ranch. I didn't grow up on a ranch, but I worked on a ranch, and it's super valuable lessons. I don't disagree with any of that. I look at this as they're here for a couple of weeks and they do some really good things, and I appreciate that beyond belief. But at the end of the day, I think we're opening Pandora's box here by saying it's okay for you to show up for a week or two and get a tax exemption. And I think consistency wise, it just doesn't work for me. Reno Rodeo, like I say, is in Reno all the time. They've got board members and staff and everybody else that that are here constantly. So that's just my commentary on the topic. You know, I think they're completely two different organizations. One is trying to help Northern Nevada solely, and you know, I think, you know, while Miss Rodeo America is an amazing cause, and I love what they do. I love the rodeo. I love all of that. I just think being consistent really makes more sense to me. So, is there any other comments from any other commissioners?
This is Commissioner Witt.
Hey, wait a minute. I'm going to go get my hat on too.
Hey, so a couple things. One, I wasn't really aware that the Reno Rodeo itself fell under a tax exempt entity. When you go to the Reno Rodeo, I would say that it is probably the most diverse population of attendees that I've ever seen. Coming from farming and ranching, I saw a bunch of that. I observed the Reno Rodeo staff network with the entity, so to speak, that represents Miss Rodeo America. I watched our current representative of Miss Rodeo America not only do an excellent job at the rodeo of representing her organization, but she also did a great job of ushering critters, cows mostly, out of the rodeo arena. And there may have been a stray sheep at one time that she actually worked with. When we look at agriculture right now, I just did a quick Google search while we were discussing things. There's only 1.3% of Americans now involved in agriculture. So sometimes, as I was thinking about it, we think that we're just, you know, this is an organization that has this pageant in Las Vegas and it doesn't have a long-term effect, but yet I don't know that we really see the effect that it has. I know I went to the rodeo twice this year. I haven't been in 20 years. And I really enjoyed it. And part of what I really enjoyed was, you know, that interaction and the education, the pageantry, and by golly, God bless America. And we're even going to pray at a rodeo. So the other issue that I have of why I'm kind of pro going against the grain is section 1 on page 63 of the brief. It actually is stated the same 3 times. It says here, this corporation shall be organized and operated exclusively for charitable and educational purposes. So that's not mincing around. I've looked at other entities that we've talked about. I have not seen or read that exclusivity. And then it says further on, this makes my heart warm. It says this corporation shall hold its primary purpose to be promoting the Western culture and way of life by educating the general public on topics including ranching and farming heritage, the agriculture industry, and the sport of rodeo. That's exactly what I saw. Okay. And I think that when we remember the Desert Research Institute getting a refund, part of that was for a rodeo that I'm assuming that the Miss Rodeo America would have been at, and evidenced from the amount of the tax that was refunded as live entertainment tax. Las Vegas didn't get to experience a lot of ranching heritage that Las Vegas just flat doesn't have. And so, you know, I think we got to revisit this thing, perhaps a remand, and take a look at the Reno Rodeo and think about it for a while. Sorry to go on so long.
Thank you, Commissioner Witt. I love your hat.
Thank you.
You look good in that. Other commissioner comments?
Commissioner Lippman, I actually can see a distinction. I think one is a local Nevada entity that is promoting agricultural activities and rodeo in northern Nevada. And Miss Rodeo is a national organization that happens to have its annual event in Las Vegas because, of course, Las Vegas is a wonderful place to entertain people and have people gather. So I actually would like to make a motion, Chairman DeVold. Is that appropriate at this time, or should I wait for more comments?
Could we wait for just a few more
Certainly,
comments?
certainly.
I don't know if anybody else, but I'll come back to you if that's agreeable. Thank you. Commissioner Brown?
Yeah, I would just say I'm very familiar with the Reno Rodeo as well, and I concur with Commissioner Lippman's assessment as well as yours, Mr. Chairman, that these are apples and aardvarks in comparison. And as you mentioned, I think you have some compelling points that the Reno Rodeo Foundation is made up of local Nevadans who serve on that board. They have literally hundreds of volunteers from our community in northern Nevada that produce that event each year. Their office is on site at the Reno Fairgrounds. They have a paid staff that reside and work in Nevada. And so I do see them as very different.
Thank you. Other commissioner comments? Commissioner Littman, go ahead and make a motion.
Thank you. I would like to make a motion to uphold the, I guess it's deny the petition for reconsideration of the department's denial of exemption status. So we're denying the reconsideration of the department's denial.
Commissioner Brown will second that motion.
Or Miss Rodeo America.
Okay. I've got a motion and second to deny the exemption status for Miss Rodeo America. Is there any other discussion from the commissioners? Hearing none, all those in favor, please signify by saying aye.
Aye.
Aye. Is anyone opposed?
Commissioner Witt, opposed.
Thank you, Commissioner Witt. Application is denied. Thank you for your time. All of the representatives from Miss Rodeo America. We totally support you and hope you continue with your organization. Executive Director Hughes, next item.
The next item on the agenda is item 6, informational items. 6A is penalty and interest waivers granted by the department for sales, use tax, modified business tax, and excise tax. And item 6B is approval and denial status report log for organizations created for religious, charitable, or educational purposes. These are just informational items, and there's no presentation on these items today.
Okay, thank you. Next item.
The next item is 7A, briefing 2 from the commission and the executive director. So today, many of you may have heard by now that Director Young's last day with the department as executive director is August 20th. She's transitioning to the governor's finance office as budget administrator. And Director Young wishes she could have been here today, but she wanted me to let you know that she found it an honor and privilege to work with each and every one of you. She also wanted to share with you how proud she is of department staff and how hard they work each and every day. These past 2.5 years, we have faced many challenges. Our credibility was questioned over the cannabis licensing, and we have faced an unprecedented global pandemic. Being an essential service agency where our work is critical to support government services, our staff have worked through the ever-changing environment, knowing the value in the work they perform. Even though we faced many challenges, we still performed and improved the services to our taxpayers, such as implementing credit cards and offering tax amnesty. Director Young wanted to take this moment to recognize the hardworking employees of the department and tell you that this agency is the best in the state. Secondly, Director Young also had a briefing for you on the modified business tax refunds. The number of taxpayers affected by the Supreme Court decision is 37,113. The total amount refunded to taxpayers is estimated to be $80.3 million, which includes taxes and interest due to the taxpayers. Since the Supreme Court decision on May 13th, the department has been working on the refund plan, developing solutions, and meeting with stakeholders, which includes the treasurer and controller's offices. To date, the department has absorbed the costs and provided resources for planning and development of the solution for initiating the refund checks. The department has taken the following steps to initiate the refunds. We sent notices to taxpayers requesting that they update their addresses and ensure their tax records are complete. We provided a press release requesting taxpayers to contact the department. We utilized social media to get information out to taxpayers. We extended our call center hours for a 2-week period to allow for taxpayers who needed the ability to communicate outside of normal business hours. We assigned revenue officers to reach out to taxpayers who may have invalid addresses or other taxpayer issues that would prevent the department from issuing the refund checks. It is estimated there are 15,000 taxpayers who need intervention of department staff to accurately process the refund amounts. We sent the first data file to Wells Fargo for printing of the refund checks. With this first file, 22,621 taxpayers will receive refunds in the amount of $30.6 million. The department will continue to process the remaining refunds as taxpayers respond to the department's inquiries to ensure the completeness of their taxpayer records and verify that we have valid addresses. We will be doing taxpayer outreach to be able to process the remaining refunds as quickly as possible. We are asking that any taxpayer who has not received their refund checks in the next few weeks to reach out to the department to discuss any outstanding items that may be needed to issue their refunds. Additionally, the department has a team of employees who are working through each taxpayer account to validate the credit so we can process the remaining refunds. It is estimated that this will be an ongoing process and the checks will be distributed on a monthly basis during the weeks of September 13th, October 11th, November 15th, and December 13th. After the end of that period, the department will evaluate how many refunds are remaining and when the refunds will be completed. Moving on to the next matter, as at the previous tax commission meeting, Chairman DeVold asked us to look into the volume of insurance premium tax refunds and a potential solution. To summarize, the department automatically applies credits received from the Division of Industrial Relations. However, these credits can be used in multiple years. Therefore, we're looking for a system solution to no longer automatically apply the credits, but to have the taxpayer take the credit on their tax returns. If there are specific questions, the department has Joe Lynn Smith, Excise Tax Manager, available for questions. And this concludes the briefing from the director.
Thank you. Thank you, Director Hughes. And also I'm sorry, was it Jolynn Smith?
Correct.
Thank you for that work on that. You know, I think it got cumbersome for us to collect money, refund money, and then do all of the wrangling with the insurance companies on that topic, and streamlining that, I think, saves time and energy inside the department. So thank you so much for tackling that problem. Okay, thank you very much. The next meeting is October the 4th. 2021. Is there any public comment at this time? Please use the raise your hand function or dial *9 for public comment, please.
I don't see any public comment.
Okay. And I think previously we had one item for future agendas. Correct.
It was the Desert Research Institute, LET events, I believe.
Correct. Yeah. I think all of us were curious, and maybe Director Hughes, if you could maybe just comment on why the DRI is involved in monster truck shows. I think we'd really, I think it's probably more our curiosity than anything else. So thank you for that. Okay. Any other items for future agendas from anyone? Okay, very good. We stand adjourned and have a good rest of your week. Take care, everyone.
Thanks.
Nice hat, Craig.
Thank you.